got this. You don't need her anymore. Or you told Beth you got this. You don't need her anymore.
That's what I'm gonna respond back to.
Is she retired?
No, I love it.
Yeah, I hate it when people that
No.
do everything leave.
Oh, you know,
It's the
just
worst. And you replace them with some young upstart, and you're like, I like your enthusiasm, but I really just want someone that knows the answer. Yeah. Literally, I don't know where we're going. There's not a
Oh, okay.
intersection in this entire county. Yeah. Because people call and they'll say, hey, what about this old gas station? Oh,
Three.
it used to be this, and then before that it was this. And
Two
it
now.
would take me an entire day of like pulling files and looking at the assessor's website.
Page 21.
No, yeah. Oh, that's so and so. He's a jerk, or that's so and so. He's easy to work with, and I'm like, oh man. For real, I got lots of JC's the same.
And Hayes and Charles.
I didn't realize we have another commission meeting. Like a full day of briefings again Friday.
Hi.
Do it again. It looks like a really short
Lori, are you good? Okay. Good morning, everyone. The time is 9:01. I hereby call this Citrus County Code Compliance hearing for Wednesday, January 15th, 2025 to order. For these hearings, we usually follow an agenda, a copy of which is posted outside. You may have a copy with you. The first item on the agenda is the call to order. The second item on the agenda is the pledge to the flag, so I'd like to ask you to join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
All right, the next item on the agenda is approving the minutes from the December hearing. I have a copy in front of me, which I have reviewed. Are there any proposed modifications, changes, deletions, additions? All right, hearing none, I'm going to go ahead and approve and sign them.
Staff update, abated, and continued cases are listed out front.
Okay. Good morning, ladies and gentlemen. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over your hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd appreciate it if you'd pay attention. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present that case. You will then have an opportunity to cross-examine any of the county's witnesses, and you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence or make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask whether or not you are contesting the violation. If you do not contest the violation, I will assume that a factual basis for the violation exists and proceed to ask you how much time you need to fix it or to work with the county. If this is all it takes, this will help save time for yourself and others. But you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although people may be upset or even passionate about what they have to say, all witness testimony should remain civil, and you should not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that I give you a time to comply before the fine begins. You must fix the violation, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county has the right to foreclose on that lien or to seek money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by the county laws. I incorporate this into all my orders as standard provisions. If you bring your property back into compliance with the law during the time that I allow, the cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs. I may allow for a continuance of the case if I find the need for further evidence or argument. And otherwise, you do have the right to appeal any order that I make today as provided by law. Thank you.
First case today, Hazel S. Jefferson, case number 2024-1346. Licensing Compliance Officer Timothy Williams, page 25 of your agenda. Expert on the case, Samuel Acosta, Certified Building Official, Land Development Director, Joanna Katu.
Are you ready, or what are we?
She's got to swear. She's got to swear.
Yeah,
Oh, okay, gotcha.
you can come up right there. I'm sorry.
Are you Ms. Jefferson?
Yes.
Okay.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right.
Morning.
Good morning.
Morning. Timothy Williams, Citrus County Licensing Compliance Officer. This is case number CE 2024-01346, Chapter 18, Article 1, Section 18-A. Obtain after-the-fact permits for all construction or modification of the Citrus County Code of Ordinances. The address is 6408 South Tropicana Avenue, Lecanto, Florida. Property owner Hazel S. Jefferson. Good service via posting the property and the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during the initial inspection on July 8th, 2024. Photos taken of my corrective action inspection on December 4th, 2024. And final inspection on January 14th, 2025. Exhibit B, a copy of the notice of violation, notice of hearing, pre-order, hearing, pre-hearing order, and a copy of my posting affidavit and a photo of the NOH posted at the property.
Okay, thank you, Mr. Williams. Ma'am, are you contesting whether or not a violation exists on the
No.
property? Okay. Then, in that case, let me ask Mr. Williams, what needs to be done on this case to fix the
One of
issue?
the sheds were removed, and they are working on getting a permit for the second shed.
So it was the shed removal not
There-
allowed to be
There were
removed?
two sheds.
Yeah.
And one was removed.
Oh, okay, so there were two violations. They were both unpermitted. One's been
Correct.
removed, there's only one issue left.
Correct.
Okay. Ms. Jefferson, how long do you think you'll need to fix this issue?
I've already got the permit number. I've already got it going. I'm just waiting for it to be processed.
It's a permit to keep the shed and have it approved?
Yeah, it's a new shed.
Okay.
I just didn't get the permit for it like I should have. I got it on the weekend and didn't get it.
All right, so you've already got an application in.
Yes.
Mr. Williams, how long about do you think that process takes?
They haven't, all she turned in right now is an application sheet,
Right.
so it can't go anywhere, it needs plans.
Yes, I have all the plans ready.
Okay.
Yeah, yeah, yeah. Well, so that's what I'm asking, is I'm just,
Yeah, so it's not quite ready to start going for it, but yeah.
is this the kind of thing that needs,
2 to 3 weeks needs,
okay. So you think 30 days, if there's some kind of revision, might be reasonable, or 45 days?
It's a prefab, right?
To apply?
It's a prefab.
Well,
Yeah,
to abate the violation. I mean,
month.
I
When-
mean, once she applies, that would be possible. That'd be doable, very doable.
okay. All right, what's the county's recommendation?
Citrus County Licensing Compliance Division respectfully requests special master assign a $50 a day along with the administration cost to begin after you date that's deemed sufficient to abate the violation and the respondent's responsibility to contact the License Compliance Division when the violation has been abated for us to re-inspect.
Okay, is there anyone from the public who wants to be heard on this case? Ma'am, I'm gonna give you 45 days to bring the property. I think that's more than enough time based on what I've heard, but just because you've already been working with them and fixing the violations, if the property's not brought into compliance as ordered, there'll be a $50 a day fine, okay?
Yes, ma'am. Or
That's
yes,
it?
Sorry.
Well, I get a lot of that. Thank you. Appreciate it.
Nervous.
I've heard worse, if it's any consolation.
So I
Next.
can-
I'm sorry.
You can go,
Done?
that's it.
Okay,
I mean, a written order will be issued, but I encourage you to keep in touch with the county.
okay.
Thanks.
Next case, Brian K. Roderick, case number 2024-0750, Licensing Compliance Officer Timothy Williams, page 31 of your agenda. Expert on the case, Samuel Costa.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Please state your name.
Brian Roder.
Thank you.
Good morning, sir.
Is case number CE 2024-00750, Chapter 18, Article 1, Section 18-A, obtain after the fact permits for all construction or modification of the Citrus County Code of Ordinance. Address is 5785 South Marlin Drive, Floral City, Florida. Property owner Brian K. Rodick and Catherine L. Bush. Good service of posting at the property in the Lecanto Government Building. I would like to authenticate the following documents so they be admitted into evidence. Exhibit A, photos taken at the initial inspection on April 18th, 2024. Photos taken at the corrective action inspection on December 4th, 2024. Photos taken at the final inspection on January 14th, 2025. And photos from the Citrus County property appraisers on April 21, December of 21 and 22, and May of 2024. Exhibit B, a copy of the notice of violation, notice of hearing, pre-hearing order, and a copy of the posting affidavit and photo of the NOH posted on the property.
Okay, so, sir, I'm curious. And first of all, how do I pronounce your last name?
Rodick.
It's Rodick? Okay. Mr. Rodick, are you contesting whether or not a violation has occurred?
Yes, sir.
Okay. All right, then I'd like to ask you to take a look at the exhibits that he's proposed, which are exhibits A and B, and let me know if you have an objection to them being evidence in this hearing.
That's what it was.
Okay.
And take your time.
Okay. Yeah, we'd probably object to them.
And what is are you objecting to the photos or also the notices, everything? And if so, what is the basis for the objection?
No privacy concerns, really.
Bless you, I'm sorry.
Privacy concerns, probably.
So constitutional, they don't have the right to take the photos?
Just privacy, whatever you, yeah, whatever's fine with me, whatever.
All right, then I'll reserve ruling until I can see the photos.
Okay.
And, Mr. Williams, could you take them and, just so I know, is there anyone from the public who wants to be heard on this? I don't see any response. All right, thank you. So, Mr. Williams, first let me just ask you a couple questions. The photos that have been presented to me in Exhibit A, where did you take the photos from?
From the street.
Okay, just let me take a look. So, Mr. Riddick, I always want to deal with the objections as they're made. I mean, if he took the photos from the street, he, like anyone else, can do that.
That's fine.
Okay, all right. Then what I'll do is overrule the objection and admit Exhibits A and B as evidence. And what's your case?
On April 18th, an inspection was conducted at 5785 South Marlin Drive. Photos were taken regarding a room enclosure, renovations, and unpermitted structures on the property. A notice of violation was issued on April 25th, 2024, and at my corrective action inspection on December 4th, 2024, the property remains the same without an issued permit, and on my final inspection on January 14th, the property remains in violation without any issued permits.
Mr. Williams, can you be more specific about the work that's been done that's unpermitted?
There was a screened-in room at the front of the home that was enclosed. There is a big barn-like structure between the home and the other garage structure. He has to re-side the house with some siding.
Can you come and point out on Exhibit A what's unpermitted, if you would? And
This is the way it used to look. Property appraisers.
okay, so you're looking at pages 1 and 2, and you're saying that's the way it used to look.
Correct. The siding is gone.
You're now on page 3. So are you saying that the removal of the siding is a violation?
The replacement.
The replacement of the siding.
Yes.
Okay.
The front screen porch was enclosed.
It was
on
in.
page 4.
And so you're saying, I just want to make sure as we go that I'm being clear. So you're saying that the removal of the screen enclosure is a violation?
Not the removal of the screen, but the enclosurement of that room from screen to a hard siding.
Okay, so the change from a screen enclosure to a hard siding is a violation?
Porch, yes.
Okay.
And that's what was enclosed on page 7.
Okay.
And this building here,
So you're on page 8.
page 8, this building has no permit. A long structure on page 9 where the pin is. Same again. And those were my follow-up.
Okay. All right, I think I understand what your case is. All right, have you had contact with the owner about this case?
Yes, I have.
Is it Mr. Rodick who's here in the room?
Yes, he is.
All right, tell me about what your conversations have been.
We discussed on how to go about getting permits, and it's been a while and nothing has ever happened. And he explained to me yesterday he was probably going to try to get an agricultural exemption,
Okay.
and that was the last of it.
Okay. All right, Mr. Ruddick, I definitely want to hear your side of this.
Well, I believe that under the guidelines of floriculture and horticulture, that I don't need a permit for those structures. And also under the Right to Farm Act, I should be free from harassment from such practices. So that's where I stand on that.
How big is this property?
It's 2.5 acres.
Okay. And what are the bona fide agricultural uses of the property?
I raise flowers and grow flowers. I do compost, and I also take the algae from my pond and incorporate it into the compost and make a new product that's rich in iron and other chemicals and stuff like that benefit certain other people that buy it.
So the thing about the Right to Farm Act and those kinds of laws is they don't necessarily exempt one from the building code, if you will. And so I'm curious, what about those laws exempt you from having to obtain a permit to modify these structures or to add the back structure on your property?
So the stuff that's needed to perform my farming act is those structures, and also, so if I hang a flower from that post, that's floriculture, horticulture, and floriculture. I don't need a permit to put a post up, or build a structure to display my product and stuff like that. And enclosure for to make a greenhouse inside to grow my seedlings and stuff like that. It's too cold out there. I don't need a permit for that, as far as I'm concerned. So that's where I stand on the whole thing. And yes, I have in the process of doing the ag exempt, and I believe her name's Lori or somebody over there, and and so I'm just in that process. I mean, I've always been doing this for the last 5 years or so, but now if it's an issue, I'll go and get the ag exempt. But that's how I practice under those beliefs.
I don't think that the tax exemption covers you for this. Ms. Harrison, what's your understanding?
I don't believe it does either. I'm actually looking at his card for the 2025 year. He is not ag exempt. It has an N on that indicator. And even if he did, he'd still have to do site development. There are still code requirements if he did qualify for that.
Right. Yeah, Mr. Ruddick, I mean, I wish you luck. I think that's a noble thing, but this doesn't exempt you from the building code. So is there any other defense you'd like to make?
No, that's just pretty much where I thought. Like I said, I got under the floriculture guidelines and stuff like that, and the horticulture guidelines. I believe it stated that you don't need a building permit to build a structure to supplement that industry.
A lot of what those rules and restrictions apply to are uses, so certain uses can't necessarily be regulated based on zoning, but the structures you're talking about here, which aren't even necessarily all bona fide agricultural, like this conversion from a screen enclosure to something that's solid has nothing to do with what you're talking about.
Yeah, well, yeah, it does, because it's like a greenhouse. That's my greenhouse in that room. I need the temperatures to stay.
But it's connected to your house.
It's
So
farm.
yeah.
I identify as a farm, so that's part of of what I do. So it's how I supplement my income, and that's just.
Okay. What's the county's recommendation?
Citrus County Licensing Compliance Division respectfully requests the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation, and the respondent's responsibility to contact the License Compliance Division when the violation has been abated in order for a follow-up inspection.
Okay. I'm going to make an express finding that the structure on the home that's been converted is not exempt from the building code, and that no showing has been made. You have a burden to show that these laws apply. I just don't think it's been met. So I'm going to find a violation. You can appeal my order. What's the requested fine?
$50
All
a
right,
day.
so I'm gonna grant you, well, is there a way to bring this into compliance? Just get a permit?
It would take a lot for engineering and permitting.
Well, sir, and also the, like when I was down there, the engineering, when I was down there, the lady said if it's not 36 inches or higher, I don't need any engineering plans for that. So there's just, like I said, there's a lot of stuff that he told, I really don't even know what some of the violations were, because it was just, like on the original complaint, they said I'll put in a pond. There's so much stuff on there that probably,
Well, let's be clear, is a pond a part of this?
There's some, there was other structure, was a dock.
Well,
on-
that's not been presented to me, correct?
Correct.
So that's not at issue today. I mean, what I would say is there any part of this that you're aware of that wouldn't require engineering?
No, sir.
Okay.
and then lastly, I believe the complainant were homeless people living on county property right there across the street from me. And so, as far as I know, their property was county property. And I would suggest that if it was county property, that it's illegal for the county to bring charges themselves. And so I would say that if that's what they were on county property and they lodged that complaint from county property, then that would make that void, as far as.
I don't understand. So you're saying people who are on county property made a complaint?
Yes, there were homeless people living there. It took me 9 months to get them removed, working with Parks and Recs. And so as a retaliatory thing, they called up and reported me and just made up a whole bunch of stuff.
I see.
And that was just, so here I'm just being harassed from that incident.
I understand. Well, what you'll find is that there's probably a fairly significant number of cases that Citrus County gets that are, if not retaliation, people who just don't get along. And it's not a basis for me to not find a violation if one exists. It's just FYI. I mean,
Right,
it's
right.
for better or for worse. That's the way that it is.
Well, not to interrupt you, but just from the counties, from going through the eviction process, I suffered, death threats and harassment constantly from them evicting them people. And they went down there, and when the day they threw them out, and they come down there yelling and screaming at me, talking about burn my house down, all this, and the lady gave me no heads up that she was going to do that or anything like that. So, I mean, it was I just find it incomprehensible that I have to go through all this for doing what I consider to be the right thing, and helping the county. They said, call, and anytime they have it, you see a mayor, call, let them know, call the police. And I did all that and worked with the county. And so I find it just kind of sad that I'm going to go through all this, but.
Well, so where the rubber hits the road on this is I need an idea, if you have an idea, of how long it would take to bring the property into compliance from my perspective based on what I've found.
Okay, so I just lost half my roof on the last hurricane. I got applications in for FEMA. I'm waiting for that approval to get that fixed. And there's, tree, it's like tree just fell over the other day. I had to take care of that. So I just got a lot going on right now,
All right.
So it's going to be significant, before I can get to that.
Okay. Is the structure in the back a greenhouse, like the on page 7 and 8? Let me just show you the photos, or I'm sorry, page 8 that's been circled. What is that structure?
I can you see it?
Let me see. Page 8 of this. I don't know if you can. Yeah, if you can come up. What is that? That's been circled. Is that your property?
Okay. I'm looking over here.
Inside the black circle.
I was never invited on the property.
Don't even recognize that.
I was never invited to go on the property.
I don't know what that is. I have a roof. What year is this?
This is 2021. Do you not
I see.
recognize, it's not your property?
Oh,
or-
okay, no, I'm looking at it wrong, okay. I'm sorry, but there's the trees and everything. Oh, my bad. I'm looking at, this is the back of my house.
Right.
Okay, I'm trying to make sense of that. It was
Me
from the
too.
front. Okay, so this is the back of my house, and that is that's how I bought it.
Okay.
Yeah, that's how it was there when I bought it.
Well, my question is, what is the structure?
The storm took that down, and I replaced it.
All right,
But that was a long time, yeah.
all right.
Okay.
All right, so I'm gonna grant you 4 months to bring the property into compliance, and if it's not brought into compliance as ordered, a fine of $50 per day.
Okay.
That's, the idea is that that would be enough time to get the plans in, to properly permit the violations.
And
That's it.
what exactly are the violations?
So like the testimony was, and I find that it's a violation, the changes in the enclosure on the front, as well as the unpermitted structure in the back. Now, if you have a structure that a hurricane's taken down and is no longer there, then I think that's not gonna end up remaining a violation, but based on the evidence, it's those two things, unless I'm mistaken.
And the siding,
The siding, yes, the replacement of the siding.
I'm not replacing the siding.
It does look like there was, I mean, you've got wooden, I don't even know what they are, posts around, not posts, planks, panels around the window in the front, plywood. And it looks like you've replaced that recently without a permit.
No, that's just the siding came off.
The siding came off. I mean, is
Yeah.
that a violation?
To re-side it, it will be. To put it back, to put the siding back on the house, you would need a permit.
But you haven't done it yet,
No.
correct?
No.
Is that required? Does he need to put the siding back on?
Yes, that's not weather resistant, what he has there.
Sure it is.
Well, hold on a second.
It's walls, it's plywood, correct?
Hold on a second. So this code section says, no person shall erect, construct, enlarge, alter, repair, move, improve, convert, or demolish any building or structure subject to this code. If all that happened was the siding fell off, he hasn't changed it. I mean, he hasn't altered it. I don't know if that, it may be a violation of the code, but I don't know how it's a violation of this section.
He will need a permit to re-side the house.
I have no doubt about that. But what I'm saying is, I don't see how it's a violation that the siding itself fell off. Does that make sense?
Yes.
Okay, so I'm not gonna find that that's a violation. I am gonna find that the conversion of the front, I'm just gonna call it the porch, and to the extent that there's an unpermitted structure in the back, that has to get permitted. You have 4 months to fix that.
Okay. Respectfully, sir, there are other issues involved, but kindly ask you, I'll need more time.
I
have,
asked, how
I'm
much.
I'm disabled, to be honest with you, and it's because of mental defect and stuff, so it's just, it's a lot for me, more than it is to you to go do something normal. It's just,
Well, I think you've acquitted yourself very well at the
Huh?
hearing. I think you've acquitted yourself very well at the hearing, and I
I'm
haven't
not talking
detected any of
about-
that.
I'm not speaking of how I'm presenting myself. I'm just telling you that what you don't see, what is normal for you, it's an enormous burden and task on me, more so than a normal person.
Sir, I've asked you how much time you needed.
I
You haven't told me, so I said,
yes,
I'm not
yes,
done yet.
I'm asking
not,
you.
no, sir. Believe it or not, I'm not done.
Oh.
So, I asked you how much time you needed. I didn't get a response. I heard about a lot of other things. So what I've done is I've assessed that based on what the issues are, 4 months would be more than sufficient. If you want more time, how much time do you need?
I would probably say about under like 11 months, probably.
I can't do that. 11 months on an unpermitted structure, it's presumed to be unsafe precisely because it hasn't been permitted, inspected, or had the sufficient plans. These are designed to protect you and the public. So even honestly, 4 months is a stretch, and I doubt the county likes that. Based on your representations, I'll do 5, but that's as far as I'll go. Okay? Thank you.
Next case, Mark Sr., Mark Jr., and Linda Almio. Case number 2024-1192, Code Officer Julie Wilkinson, page 6 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Ma'am? Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And I'm sorry, which case is this?
Page 6, Elmdale.
6? Thank
Page
you.
6.
Good morning.
Good morning.
Proceed when ready. Please.
Oh, sorry, I didn't catch that. Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 24-01192, special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 8161 West Pebble Lane in Homosassa. The property owner is Linda, Mark Sr., and Mark Jr. Alimo. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 3rd, 2024. Photos taken during a corrective action inspection on December 4th, 2024. And photos from my final inspection conducted on January 14th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Can you tell me, like, what is the alleged violation here?
So it's a vacant parcel, and there is a shed and some other miscellaneous items being stored on it.
Okay. Ma'am and sir, are you contesting whether or not there's a violation?
We were unaware that there was because when we purchased that piece of property, that little structure was already there.
Right. Well,
It's kind of like a pole barn, like people park a boat in it.
I understand. And so the issue here is, and we have a lot of hearings like this, so this is partially for the benefit of others if they're here, is that when you have I assume that it's zoned residential.
Yes.
Okay, so when you have a lot of these residential zonings, if you don't have the principal use established, i.e. a house, if you don't have the house ready to go on it, you can't necessarily use it for other ancillary things, whether it's storage, whether it's parking cars, whether it's stuff like that. Does that make sense?
Well, there is a house, but it's considered the next lot over because the house lot was purchased first and they wouldn't sell that section because they were still using it as a radio station or something for Christian radio station.
Well,
And a
then
few
I'm
years
warning
later,
you that if
decided
you
to
are
sell it.
contesting that there's a violation,
Yeah.
that's fine, we'll go through it. Would you mind showing the exhibits, and let me know if you have objections to them being evidence?
No, I don't really want to contest it. I'm just telling you that when it was purchased, that was already there, so I assumed it was okay.
Well, that's not, so, and this happens a lot too. Sometimes people buy property that may already have something going on. That doesn't mean that it's okay.
Oh, okay.
It means that and by the way, I encourage you to hire your own counsel to tell you this, but this is my perspective. So, when, if a seller represented to you that there's everything's legal on the property. There's no problems. I mean, maybe you have a cause of action against them,
Yeah.
but it doesn't mean that from the county's perspective, everything
Okay.
is kosher.
All right.
But does what I said make sense?
Yeah.
Have you had conversations with Ms. Wilkinson about this?
Yes,
Have you explained this before?
just this morning.
Oh, okay, okay. How long do you need to fix the property?
What has to be done?
Everything's got to be removed, basically, until you establish the principal use on the lot.
Okay.
So how much time would you need for that?
Week.
Yeah. I haven't seen the photos, but I suspect that's about right. Is there anyone from the public who wants to be heard on this case? Ms. Wilkinson, what's the county's recommendation?
It's gonna be $50 a day along with the administrative cost, to begin after the day you deem sufficient to abate the violation.
I'm going to give 21 days, just in an abundance of caution. Sometimes timing gets thrown off, so if it's not brought into compliance within 21 days, a $50 a day fine will accrue. Okay?
Thank you.
All right, thank you.
Do you still need this?
I don't.
Thank you.
That's it?
That's it.
Thank you.
Next case, Donna Karen Empt, case number 2024-1883, Code Officer Cody McGuire, page 24 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Can you please state your name, ma'am?
Donna Karen M.
Excuse me, I can't. I'm not sure who's, okay.
Donna Karen M.
Thanks, guys. I got you. Welcome, good morning.
Oh,
Cody McGuire.
morning.
Please proceed.
Cody McGuire, Citrus County Code Compliance Officer, case number 202401883, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 9510 West Caravan Path, Chris River, Florida. Property owner is Donna Karen Empt. Good service via signed certified mail return receipt and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during initial inspection on October 29, 2024. Corrective action inspection on December 4th. December 4th, 2024, and photos of my final inspection on January 14th, 2025. Exhibit B is a copy of the notice violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Ma'am, did you hear?
I heard but did not understand. He's talking way too fast. My ears are old,
All right.
and they're not that fast.
Well, so I'll help out. So first of all, Mr. McGuire, if you would speak a little
Yes, sir.
slower for my benefit as well. And is it Miss Empt?
Yes.
Okay. If I may ask, what's the heritage on that?
I believe it's German.
Okay.
Pennsylvania Dutch.
Okay. All right. Now, this, what's been explained is that there's two sets of exhibits. One set is a bunch of photos that have been taken, and the other exhibit is some notices that have to do with how you've been put on notice and that kind of stuff. So eventually, I'm going to ask him to show you those documents. But right now, I'd like to ask whether or not you're arguing if there's a violation on the property. You're not?
No.
Okay, so you agree that there's a violation. My question
was.
so as of today, you're saying there is no violation?
Well, as of yesterday, yes.
In other words, you brought the property into compliance as of yesterday?
Yes, sir.
Okay. Now, you took photos yesterday, correct?
Correct.
Okay. Are they going to show a violation?
They will.
Okay. So here's the thing. Has there been improvement?
Huge.
Okay. If I gave 14 days to bring it into compliance, do you think that's achievable?
Honestly?
Honestly, yes?
Yes, sir.
Okay. So can you show her your photos from January 14th? I just want to be on the same page. Sure.
So this is underneath the covered, almost maybe it might have been a shed at one time, but the siding's
What?
all taken off. It looks like a bunch of construction
No,
debris.
no, there were no sides ever. Okay. Okay. That is an antique car.
While they're chatting, is there anyone from the public who wants to be heard on this case?
Yeah.
I don't see or hear anybody. Okay.
It's
Well,
that and then the
that's,
tarp that's
there's
in
a
the fire
whole
pit.
lot of stuff under there, I think. See, that was my husband's diggings. I had the house, and he was a night person, and I'm not. So, for his working life, he acted like a morning person, but he wasn't. He would wake up at 10 o'clock, and I would go to bed.
Well, ma'am, here's what I'd like to do is I want you to understand what his perspective is on the violation so that you feel comfortable. Is 14 days enough to fix what he's showing you?
I don't think so.
Okay. Is
I
30
have to
days?
sell a car.
A car?
A car, yeah.
This is a car a part of this case, Mr. McGuire?
I never knew there was a car on there.
Well, that's red, and I think that's part of the MGB.
All right, let's do this.
Okay,
Ma'am,
is this, I need to ask him a question.
well, I can do better. Let me ask you if you have any any objection to these documents being evidence, because I need to look
No.
at them. Okay.
That's all the notices. You got part of it right there in front.
Well, I have all of it right here.
Oh, perfect.
All right. I just need to know if you have any objection to these documents. I'd like to look at them.
I didn't see but one document, but probably not. Oh, my goodness. That wasn't there yesterday?
Correct. These were
Oh,
on October 29th.
Okay, sorry. Well, show me the new ones. Okay.
The fire pit, that's the tarps. So it would be that, and then whatever's on top of
Oh, the tarps on
said
the,
car.
what time did you come?
That was at 9:56.
Yeah, well, they were still there, but they're not anymore.
Awesome.
And this is not there anymore. That's underneath the.
All right. I'm not hearing any objections, so
No.
I'm going to admit them without objection, and I'd like to look at them. Just give me a second. And the reason I want to look is I want to have an understanding of how much remains to be done so that I can give you a reasonable time to comply.
I still have a question.
And you'll have the right to ask it. So, Mr. McGuire, is the remaining violation the pile around the garbage can of junk as well as the kind of, I guess, wood and vegetative debris on
Yes,
the
sir.
last page?
Yes, sir.
All right. Now, did I hear that there's a car there hidden?
It's in there somewhere,
Okay.
I think.
Well, look, as far as I can tell, I mean, is the car junk?
It is by now.
Okay. Well, ma'am, how much time do you need to fix what's shown in this exhibit?
I have no clue. I have no idea.
Okay. You think you can, I mean, would you mind just trying to lift the car yourself? You know, like,
Yeah.
yeah. Is 30 days enough?
I doubt it.
Why? Because
Well-
to me, just looking at it, it doesn't seem that much.
Well, if there weren't a car that I had to sell or do something with, I have no idea how long these things take. I've never done this. Apparently, I've been a hothouse flower all my life. I didn't know there was a code. I didn't know that his putting all kinds of bins with stuff in them was not allowed.
Well, let me tell you this. I mean, I don't think the car is technically under this code section. If there is a junk car there,
Unless it's,
in pieces.
in pieces, yes.
Right.
Oh, it's probably, well, unless it fell apart, yes.
Okay. I'm going to assume, based on the evidence and your testimony, that it's not a part of this case. That doesn't mean it's not a violation. If you have an inoperable car, something that needs to be, you probably are going to have to get rid of that, or you're going to have to make it operable. That's not in front of me today. Let's forget that. What we're talking about is the junk, all right? The debris that's on or around it. Is 30 days enough time to get rid of this
I
little
would-
bit of?
I would think so, yes.
Okay, that's what I'm going to do. What's the county's recommendation?
$50 a day.
You've got 30 days, and if it's not brought into compliance, there'll be a $50 a day fine. Okay? Good luck, Miss Empt.
Thank you. I'll need
Thank you.
it. Yep.
Next cases is Captain Jim's Golf Carts Incorporated. I've been told that he's not contesting the violations.
Okay.
There are 9, but 3
For the
separate
record,
addresses.
in the 7.5 years I've been a special master here, I've never seen 1, 2, 3, 4, 5, 6, 7, 8, 9 cases, which I think is impressive. And, I mean, I'm impressed, but at any rate,
Yeah.
3 separate
well done.
addresses.
It takes work. It's not easy. It's not, I don't think it's easy. I think it's easy to get 1 or 2, but,
So Joanna Cantu Land Development, he's brought a contractor with him that
Okay.
I'm very familiar with that can handle this. They're gonna need, they have some after-the-fact uses here on general commercial parcels. They're gonna need some alleyway vacates and some permitting, which he's aware of. I don't think they can handle that. I think 6 months is probably a very reasonable time, and we've talked about that,
Okay.
just
Okay.
to set ahead. I know you've got a lot on
you
the
don't have an
docket.
objection to 6 months.
I absolutely do not. Maybe more, but probably enough to get the stormwater and the vacates through, yes.
And they've got to vacate some rights away?
They have some alleys in there. You can see that in that diagram right there, the little
I see.
And that
sideways
process
T.
is well underway.
Yeah.
Wow, okay.
So they've started that. They've hired somebody. They've hired a contractor, which they need to do. So I think they're well down the path.
Is this a resolution for all 9?
Yes.
Yes, sir.
Just to find that there's a violation, grant 6 months at least? I mean, do you agree that 6 months is sufficient time?
After speaking with Ms. Katu, she has a better understanding of our permitting requirements than anyone. At 6 months, if we're not complete, we're darn close.
And we can come back.
And I'll stay in touch with Julie.
Okay, it sounds like they're not gonna necessarily immediately drop the hammer if you're a few days after and you're on your way or something like that.
Correct. If he's working with us, which I think he will be, then we're
Okay.
fine.
Can you just tell me what's going on, a little bit about what's going on? I'm interested. I could do a summary, it's not a big deal.
Okay, so in the, in the,
East, north, and south.
yes, in the west quadrant of lots right there, that property has temporary occupancy of a RV, as well as they did site improvements without a site improvement plan. Oh, cool. Wait, I don't know how to use it.
Just so y'all know, this is the first time as far as I know, they've ever presented evidence this way, so there's some learning.
Got a good tech person.
Yeah, we do.
Yeah.
So that one, this right there, we're talking about this piece. So it's got site improvements without site improvement plan. It's also got on-site signs that aren't permitted, as well as the
Is
obstruction.
it commercial? I mean, is it just
Yes,
getting
it's
it? Okay.
GNC.
Well, that's all so here's what I'm just asking. I'm like, where are we, where are they trying to get to? Where are y'all trying to get
And
to?
they're trying to get to a golf cart business, which they've
Okay.
opened up there. We know the warehouse building is there. It's all Jones General Commercial, but they have some alleyways in between. And they're gonna have to do some site permits because they've expanded with some parking and storage and things. But it's doable, commercial, but we have to work with them.
Okay, then, is there anyone from the public who wants to be heard on any of these 9 cases? What's the county's recommendation on this?
Okay, so for the site modification ones, we would like a one-time fine of $5,000, as well as the administrative costs, and be required to obtain a development order or permit for the property. And for the non-site modification cases, I'm requesting $100 a day.
Have you all agreed to a one-time fine based on have you had that discussion?
That's the first I've heard of it.
That's the first I've heard of it.
Okay.
Here's a situation that
Can I swear them in?
nobody's.
Yeah, go ahead, if you don't mind.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names?
James Parkerson.
John LaFleur.
Thanks.
Nobody is looking at the situation of, we had a catastrophic fire. We lost our building. This happened before code enforcement come out and started
Days
all
before.
of that stuff. We lost what we built in 8 years in a matter of an hour and a half. So nobody's taking into consideration, we have to rebuild, and it's just like, we gotta have more time. It's just all there is.
Which we have a permit for the rebuilding process.
Fire department's got the fire marshal come out. We had a lithium battery, explosion at 1:30 in the morning.
And 2 hurricanes.
It gutted the shop.
All right, so I guess
And
we're gonna have to.
nobody seems to wanna, hey, this guy needs a little help over here. No, let's just put him out of business.
Well, it sounds like it's really uncontested that there's violations, right? One way or the other. It's some that have nothing to do with what you're talking about. So I think it sounds like that's what they're coming, and they're just outright coming, proposing a solution, and you've agreed to that, which is great. But I think you're talking about this other case where now they're asking for a one-time fine, and I guess we're gonna have to talk about this case. So
So
what?
it's 2 cases.
Oh, it's 2 cases.
Site modification is 2401-759
Okay.
and 2401-762.
Okay.
Everything else is just the $100. So for 7 of them, we're only suggesting $100 a day after the 6 months.
Okay.
And the $5,000 fine, I mean, is that?
Let's set that aside for a second.
Okay.
I want to resolve these other ones that maybe y'all have an agreement on, and then we'll talk about that. So on 7 of the 9 cases, these are things that the county doesn't deem as irreparable harm, things that you can rectify within 6 months. If it's not brought into compliance within 6 months, there would be a daily fine. They're also representing, though, that they're going to work with you on this, okay? Unless you have an objection, I'm going to put that stipulation into the record as resolving those 7, so then we can get to where we do have a disagreement. Does that make sense? No?
I'm okay with it. If they'll give me time, it's what we're doing here has been going on for 8 years, and then all of a sudden we have this catastrophic fire, and then they jump on the bandwagon and just start hammering me. I don't understand where this $5,000 fine comes from.
Well, let's set aside the fine. I'm talking about all the other violations, and a lot
In
of
6
times,
months, we can pretty much-
things go on for a long period of time, and the county doesn't even necessarily know
We
that there's.
concur with the $100.
Okay. But I'll just explain. I get what you're trying to do. But let me explain for your benefit, okay? And you may understand this fully, but the thing is that sometimes they don't even know that there's a violation, or the county doesn't necessarily know. Then they learn about it, and it is what it is. So it's not a case that necessarily, if you've had something the way it is for 8 years, it doesn't mean it's okay if there's a violation. Now, I'm not even we are gonna fully address the fine issue. I just wanna get the resolution on the 7 cases, and my understanding is that there will be no fine if these other things are fixed within 6 months, okay? Is there any objection to that?
None.
All right, so what we're gonna do is, we're gonna have orders on case numbers 2024-1525, 1754, 1756, 1757, 1758, 1760, and 1763, where I find that a violation exists, but grant 6 months to bring the property into compliance. If it's not brought into compliance as ordered, $100 a day for any of the given violations. Okay. Now let's talk, and I don't even understand what the issue is, so I have to hear from the county first on what they're claiming on case numbers 1759 and 1762.
Okay. So starting with 1759, we're talking about, wrong button, here, this parcel right here, okay? That's gonna be address 8379 West Grover Cleveland Boulevard, AKA 3952 Illinois Terrace, Homosassa. It's owned by Captain Jim's Golf Carts. I have good service via signed certified mail return receipt. I have in Exhibit A, photos from an initial inspection on October 1, 2024. Photos from a corrective action inspection on November 27th, 2024. And photos from a final inspection on January 14th, 2025. And an arrow from the PA website dating October 8th, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, so before we get to that, tell me in a narrative form what's happened on this property.
They cleared the trees, graded the property, and put rock down.
I was with you, clear the trees,
Graded the property.
did what?
Grade.
Oh,
Grade.
graded, okay,
Yeah.
got it. Graded the property and
Put down rocks.
put down rocks. So, it's been cleared, it's been graded, and it's been improved,
Yes.
okay? And what are you requesting for this case?
It's gonna be $5,000.
Now, are you requesting 5 on each of the two?
Yes.
Okay, so that's $10,000 you're requesting.
Yes.
Okay. We don't have an agreement on that, and so what I need you to do is show your exhibits to the other side and let me know if you have any objection to these exhibits being in evidence. And I'll hear your side, by the way. It's just a matter of talking about the evidence first. Do y'all have any objection to these exhibits?
No, sir.
That's the exhibits, no, sir.
Okay. Then what I'm going to do is I'm going to admit them without objection. I'm going to take a look at them first. All right, is there anything else you want to tell me about this case?
That lot is 0.06 acres. It's zone GNC. And when I spoke with Mr. Parkerson, when I first went out there, he said that they had begun doing work about 2 years ago. That's all I have to add.
Was there a complaint about this?
Yes, so the original complaint was for RV occupancy, and then when I got out there, I realized there was more violations than that, and then after further research, I realized there was even more violations.
Okay.
So that's how it turned into this.
I'll just tell you my initial thoughts. There may be a technical violation, but it looks good.
Oh, it looks beautiful, yes.
Okay. All right. I'm going to reserve ruling on this because I want to hear what your other case is.
Okay.
In other words, I don't want to really come to a conclusion on this without hearing what the other case is that they have against
Do
you.
we get to talk about this?
No, we're going to.
Okay.
Well, actually, no. I apologize. Tell me what you'd like to tell me right now on this.
She very well knows this because she has been told. Duke Power hired contractors when before they put the High Line in, they come out. I had to sign a paper, state for them to take those, I think it was 9 cypress trees out, very large cypress trees. They took those trees out. Captain Jim Golf Carts did not do that, and she knows that.
So I want to make sure I understand what you're saying. So on this parcel, with the rocks, you've got some golf carts on.
Everything on Grover Cleveland of the right-of-way.
But so that there were are you saying that any trees that were on this lot were removed by Duke?
Well, there might have been some underbrush, but no, there was all of the trees that
Yeah, I don't
was
think you're
interfered
forbidden
with the
from
High
removing
Line.
underbrush.
Right, and I would add that the term clearing is a misnomer that
That's not
Ms.
correct.
Wilkerson's used. There was a few selective trees removed, and the majority of them by Duke Energy. So I think clearing is the wrong term.
As far as I know, all
for
the
this
trees
case.
was removed by Duke Power's contractors
And why did Duke do it?
because they put the High Line in. They redone the
They ran a new
entire
power line on,
power line. They put the 60-foot
Grover
high
Cleveland.
line in, and they took out, they did 100-foot vacate of anything that may get in there, a grove and,
Yeah,
for their
that-
power
that-
lines.
That was Grover Cleveland from terminus to terminus. there.
I see. So it didn't have to do with anything you were doing on the
No,
property.
But they left stumps this high throughout the whole front property, so I paid out of my pocket to have the stumps ground. And I took my tractor, I graded it, I had some rock brought in, and I put rock down, so people, that's where we sell our golf carts, which is out front. And all I did was just make it where people don't walk through mud and they can shop, have a nice something like, and made the county look better and.
No,
get in
sir. Do you know what the
trouble for it.
gravest sin in the world is? Doing a good deed. So, you know, you made your property look good and it's better for the people, but at the same time,
There was no water direction, there was no nothing,
Right,
it's
we
just
did
something to
not change
stand
water
on.
flow.
Just something for the people to stand on. And I spray weed killer out there to keep the weeds out.
no, I mean, I know, it's painful, but the thing is like, you have to know this. You're responsible for following this. It's not something we learn in elementary school, middle school, high school, college, law school. Well, I won't speak for you, Ms. Harrison. I didn't.
have it.
And yet, it's something you have to follow. And but that's why when there is a violation like this and it comes in front of me, there is some discretion on the fine.
Right. Mr. Wild, first of all, that fine sounds like a criminal offense that we're being fined.
Actually, criminals don't get charged that much, usually.
Thank you.
I know, I mean, unless there's actual theft and it's grand theft and you have to reimburse, it's just the case.
And I
mean,
will say, on record, I think some of Ms. Wilkinson's representations are incorrect and false. Some of her terminology, I should say.
Well, that's a serious allegation. I've not encountered that I know false representation. What is false? What was falsely
The word
represented?
clearing, in particular.
Well, I think that's a term of art. So what I think they mean is, it's clearing when there's stuff on there and then it becomes usable. In other words, now it's passable. Now you can drive things on, and as the testimony said, it's much easier for the public to walk. It's better for the public, And again, the county's indicated it's going to work with you. Now, I definitely understand your point. I'm going to take it into consideration, what you've said. I'd like to hear what the county has to say on the other case.
Yeah, so the other case is gonna be the lot right next to it. It's identical in everything.
It's like .06?
Yes,
So we're talking about .12?
Each one of them are .07.
Oh, okay.
So you were talking about 3 and now you're talking about 2?
No, so down in block 3, use your pointer, Julie. Down in block 3, there are 4 separate
Right.
lots. The first one, Julia, that you were testifying about, is that the far right one?
yes,
The one you're testifying about now, is that the one directly to the left of it?
yes.
Yeah.
Okay.
So that's why I said .12. It says .06, .06. I added it in my head, and I think that's,
You're on top of it.
okay. No. I just want to make sure we're on the same page. So, all right, so what's the issue? The same stuff you're saying?
Same stuff, yeah.
Again, I'll talk out loud since I'm going to think as I speak, which is the county does have an interest in deterring people from not going through the proper site planning, because when there's regrading, that can affect drainage, that can affect other things. And I'll tell you, we have a lot of these cases. So usually it's cases where someone buys a quarter acre and they say they're not aware, but they cut down the trees so they can build a home or something like that. And, it's usually not with felonious intent, but the code, I think, gives me discretion up to $10,000 per violation, so that they request $5,000. I want you to have a chance to speak about the second property, if you would, if it's any different than what you said about the first property.
I'm not sure what she's doing with the second property.
She's saying that there's the, I mean, I guess it's the same.
It's that front that you're looking at right there, that's strictly down Grover, Cleveland, that's where all those properties are the same.
It looks like
thing.
what's the property where there's containers or were containers and an RV and,
So the containers are in the alleyway, and the RV is also in the alleyway.
I see.
Yeah.
Okay.
The RV's been sold, Mr. Wah, and again, we're in the process of vacating the alleys. That will become Mr. Parkinson's property at that point.
And just for the record, can we have the evidence put in for case 2, since we do have separate documents?
Not yet. I'm aware. I'm working through this. So, so Ms. Wilkinson, I guess, is there anything different about the violation on this one from the previous one?
No.
Okay. And is it that the gravel covers both?
Yeah, the
Does
gravel's
gravel
going
cover
across both, yeah.
Okay. I mean, it doesn't seem like these are big parcels.
No.
Are you aware of concerns with the drainage?
I am unaware.
That have been created by the regrading, so to speak?
I don't know. I don't know anything about the drainage. I've never seen any flooding or anything there. And there's like a dip, like a swale, like in the right of way. So, but I've never seen flooding.
Is the sometimes I just need to be educated, but is there is the gravel less porous? Is it less able to drain because of? Do you know?
It's treated like impervious surface, like
Is it?
pavement. Yeah, there's only certain types of gravel that's not. Most of them are treated like impervious. This is all part of a permit he could do, the grading and the rock or something with the permit with the rest of the site. So that particular thing we can't address. It'll be part of his stormwater plan.
If it can be permitted.
The grading and the fill. Yeah,
So the county's requesting the fine because of the clearing,
that's my understanding, yes.
Yes.
not because of the other stuff, because that can be a part of the permit, i.e. fixed.
Yes.
Okay. All right, Ms. Harrison's right. We do want to introduce these documents and evidence. Do y'all have any objection? Take a look at these and let me know if you have any objection to them being evidence.
No objection.
Okay.
I'm not understanding, why would you fine me for the trees that I didn't take out? These are trees on the right of way. They went back 60 feet.
Yeah, and I would mention, Mr. Wall, that, we can submit, that little bit of documentation for Duke Energy. And as part of our permitting for the tree removal and the grading in the impervious surface area, we'll include landscaping. So, in that book, there's a big chapter on landscaping, so.
Yes, there is.
Trees are something that we can replace. I'm not,
Well,
making light of the fact that they were removed, but we can replace trees.
If Duke hadn't removed the trees, what would you have used this property for, if anything?
I didn't want the trees taken out. They're beautiful cypress trees that was 40, 50 feet in the air. I loved them. I didn't want them taken out, but that's the progress of
Duke Energy's the only one in the world that can cut down 40-foot cypress trees without permitting.
We have to show them
And I'll
what we're
push
calling
back on
Exhibit
that.
C. We're
Okay.
adding one exhibit to this.
All right.
What's this for?
And
It's just an actual photo, yeah.
could I hear
Those are
what?
the trees that were removed, right?
No.
This was before tree,
These trees right here, this is a right-of-way right here, best of my knowledge. Oh, she's talking about down this side.
Where did
Do
Duke
you have an
remove trees?
objection to the photograph?
We'll hear what it's about, but do you know what this photograph is? Can someone
photograph
represent
of the
to them what
business.
this is a photo of?
So the photo is showing the two pieces of property after they've been cleared of the trees.
From the property appraiser's website?
From the property appraiser's
Okay.
website, yes.
Okay. So they want to talk about it and they want me to review it. So I'd like to see it. Do you have any objection to it being evidence?
No?
Okay. Then we'll have it be Exhibit C as the county proposes. And so let me take a look. So the point, what is the point of this Exhibit C?
Do we have a
If I
before
may,
photo?
Your Honor?
Yeah.
Exhibit C is an overhead from the property appraiser's website. It shows what is depicted on the overhead up here, each of the parcels with the rights-of-way. It also indicates the clearing, how far back they've gone on the parcel, and that the two left-hand parcels, which are not at issue in this matter, have the same Duke Energy running in front of it, but do not have the same clearing. So it shows that their testimony is inconsistent with the physical evidence that we have before the court, just for the court to take that into consideration when considering the amount.
In other words, you're saying that if they were being consistent, then I guess I don't know the direction of it. Oh, that the south side of the south side of the western two parcels also would have been cleared?
Yes.
Okay.
As you can see, the energy line running in front of it in that property
I
appraiser's.
do see that the power line runs all the way across it. I really don't understand why they would have cleared all the way back on these parcels. And especially if they didn't clear the southern portion of those western parcels.
That's not an accurate photo. That's not current. Theirs not.
They agree with you, but what that shows is the way it was, and this photo is current in Exhibit C, which is why they wanted to admit it, and that shows me that what they're suggesting is this Duke explanation doesn't really explain the evidence, because if it was Duke, they would have cleared the southern portion of those western parcels and or not gone as far north as they did, I think, necessarily on the eastern two parcels.
We took
Is
no
that-
trees out the front of that property whatsoever. Absolutely not. Absolutely did not take any trees off the front of that property. There was some underbrush.
Right.
There was some small stuff. No cypress trees was taken out.
I'm just trying to figure out why Duke would do it.
Because of the High Line.
I think I see the High Line, but I don't understand. I mean, I see it, but why would they have to clear?
Did they run a guy wire down back that way, Jim?
I do see why they would clear the trees that I'm looking at on the south side. I don't understand why they'd clear the north side. That makes no sense.
What are we looking at the north side? I see the north side. That's the right of way. We're not on the same page here. If I'm catching up what y'all trying to say, that where the 1 and the 2 is, all of that was already.
No.
cleared.
I'm looking at Block 3, the north side of the eastern two parcels.
This is 2 in where the.
Yeah, you
pinwright
see where it
is at the
says
bottom.
.06 and .06? I mean, I don't, thank you. I don't care. I don't know how to do this. Top?
Yeah. And then.
No, it's not gonna work.
I don't, listen, folks.
Did they run some
Julie,
front
yeah.
Yeah, okay, I got rid of it. There you go.
Trees took them
care of
off,
that.
so I-
She's coming up.
I'm sorry.
I do that a lot with her. She's used to me doing it, so there it is.
Okay,
There we go.
so there you go, to the right,
No.
No,
Right.
yeah.
Yeah.
down, right
Right about,
there,
Bingo.
those two pieces.
yeah, so those are the two we're talking about. And I'm just talking about the north part. Yep, that's right, Ms. Wilkinson. The clearing that took place on the north part of those two, there's absolutely no reason for Duke to do that.
I'm not seeing what you're saying. We cleared, there's clearing there that's.
That was that photo we just submitted. That showed,
Can I-
that's.
Sir, come on up. Let me show you
that's
what
a
I'm talking
before,
about.
That's an after.
So, what I'm saying is, here's the lines, okay? I'm looking at Exhibit C. I'm looking at Exhibit C for the record. I get why Duke might clear the southern. This is the southern part of these parcels. What I don't understand is why they'd clear this part of the northern. We can see from the old photo that there's definitely trees there.
All right, there was 2 dead pine trees in this area that I had a tree company come out and remove. Those 2, it was right here off to the corner.
Okay.
Anyways, lightning struck pine trees. I took those
Okay.
out, but that was in several years back.
All right, thank you. y'all have anything else you want to say about these cases?
And that was by a tree service, Dwayne Watson Tree Service. They
Okay.
can verify they was dead and would be falling.
Ms. Wilkinson, is there anything else that you want to offer?
Nope.
Okay. What I'm going to do is find that a violation occurred in each case based on the north side clearing and assess a fine of $500 in each case.
Thank you.
And is there anything else?
I believe we requested that the site modification cases, Ms. Wilkinson, correct me if I'm wrong, also include them getting permits for the things they could have gotten permits for, such as the grading and the rock.
Yes,
Okay.
yes.
Oh, yeah, I mean, okay, I'll so find, if you agree.
Say it again, sir.
To get the permits for the 2 lots here on the number 3 cluster, that you get the permits for the rock and the grading.
Oh, yeah, it'll
That
be
makes sense for
site-wide,
that.
yeah.
I mean, that has to
All-
be.
all inclusive.
Okay. All right, that's it. Thank you very
What
much.
would be the time limit on getting those permits?
The 6
No,
months.
it's part of the 6 months.
Oh, okay. Thank you.
Next case, Joshua Cole and Nick C. White, case number 2024-2060, Code Officer Erica Olson, page 34 of your agenda.
Thank you.
You welcome.
I very much appreciate that. Hello, ma'am. How are you?
Good, how are you?
Good morning.
Good morning, sir.
Mr. White? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
do.
Please state your name.
Joshua Cole White.
Thank you, sir.
No
Thank you.
problem. I'll be representing Nick White as well.
Okay. All right, please proceed.
Erica Olson, Citrus County Code Compliance Officer, case number CE 2024-02060, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20, Tax 61 of the Citrus County Code of Compliance. Address is 6701 South Wildermuth Point, Homosassa. Property owner is Joshua Cole White and Nick C. White. I have good service via posting the NOH on the property and posting at the Lecanto Government Building. I would like to take the time to authenticate the following documents and request that they be admitted into evidence.
All right, let me just ask, are you contesting whether there's a violation?
There is not. I was just asking, it would ask for an extension on getting it cleared. That's
How much time do you need?
2 weeks at most.
Do you have an issue with that?
No, sir.
What's
He's
the-
made progress
What's your
already.
recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with an administrative cost to begin after the date you deem sufficient.
Is there anyone from the public who wants to be heard on this case? All right, then I will find that a violation has occurred. I'll grant you 14 days to bring the property into compliance, and if it's not brought into compliance as ordered, fine of $50 a day.
Okay. Just get clearing the vegetation, basically, yes.
Yeah.
Okay.
All right. That's fine. We've already talked on the phone, so
No,
everything's
that
okay.
works.
I'm sorry for wasting your time, sir.
No, thank you very much.
Y'all have a great day. Thank you, sir.
Thank you. Yeah. Next case, AmirHouses.com LLC, Code Officer Erica Olson, page 7 of your agenda.
Now, Amir Houses is not a stranger to these hearings. Welcome.
Thank you.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
Please state your name.
Chris Chambers.
Thank you, sir.
Thank you.
Please proceed.
Erica Olson, Citrus County Code Compliance Officer. This is a repeat violation. The initial violation was observed on November 26th of 2024, and the address for that violation is 7434 West, or for this violation, I'm so sorry, is 7434 West Clearbrook Lane, Homosassa, Florida. Case number 2024-02033, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20, Tac 31 Alpha of the Citrus County Code of Ordinances. The property owner is AmirHouses.com LLC and has been previously found guilty of the same violation at a different location at 4195 North Gary Point, Crystal River on August 23rd, 2024. Case number CE 2024-060477 with $0 and imposed fine. This case has a compliance inspection of February 24th, 2025. I have good service.
I'm sorry. February 24th, 2025?
Yes, so.
Oh, a compliance.
A
Gary
compliance date you gave until February,
For the Gary Point address.
for the Gary
Oh,
Point address.
I got you. Thank you.
Sorry. I have good service via posting on the property and posting at the Canto Government Building, and assign certified mail return receipt of the repeat notice.
Okay, so can you tell me what your proposed exhibits are?
So I have Exhibit A, the findings of fact for the original case, CE 2024060477. Exhibit B, photos I took during my initial inspection on November 26, 2024, and photos I took during my subsequent inspections December 3rd and 11th, 2024, January 7th and 10th, 2025, and photos from my final inspection yesterday, January 14th, 2025. Exhibit C is a copy of the notice of violation and hearing sent to AmirHouses.com LLC, a photo of the notice posted on the property, a copy of the posting affidavit, a copy of the certified mail return receipt, a copy of the SunBiz, and a copy of the pre-hearing order.
So, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them.
And this is the ones we just looked at outside, right?
Well, we looked at the ones from yesterday, but these are from all of my inspections.
Okay. And this is just Clearbrook, correct?
Yes, sir.
Okay. Now, that's the truck you had him removed, correct?
Yes, sir.
Okay, because I was gonna say that one's still there.
Nope, that one's good.
Okay. And they did do a major cleanup compared to when I was out there last night.
And then these are just.
Yes, ma'am, I'm aware of that.
Are you good with them?
Yes, ma'am.
Sir, do you have any objection?
No, sir.
All right, so exhibits A through C are admitted as evidence, and just so I know, is there anyone from the public who wants to be heard on this case?
I'm sorry.
Oh,
This is the findings of fact for the original case.
okay. So that's exhibit A? All right. Thank you. All right, let me just take a moment to look through this. All right. All right, please proceed.
On November 26, 2024, I conducted my initial inspection and observed the property to be in violation. Items observed in my initial inspection were small piles of miscellaneous items in the backyard and cuttings from a tree. I gained access to view the other side of the backyard from the neighbor who let me use his property. From this angle, I was able to see that there were items such as spare wood, metals, bed frame, a tank, trash cans without a lid, a window air unit piled up behind the shed. I could also see inside the shed as it was damaged, and I could see that it was full of junk. Prior to leaving the office for this inspection, I had conducted research and found that this would be a repeat violation. I posted the property for the repeat offense of the above-mentioned ordinance. On December 3rd, 2024, I conducted a subsequent inspection and found that the property remained in violation. On December 11th of 2024, I conducted another inspection and then was able to make contact with the tenant's nephew, Kelvin Bozeman. Kelvin allowed me onto the property, and I walked it with him to show him what was considered violations. This included the area behind and next to the shed. During this inspection, I was able to see by the back door of the house that there were appliances and other miscellaneous junk and debris piled. I conducted subsequent inspections January 7th and 10th and found the property remained in violation both times, but progress had been made.
Did they have an explanation when you inspected with them as to why it was that way?
They just mentioned that they were having some medical issues. As to why the junk got so out of hand, I do not know, sir. As of my final inspection yesterday, January 14th, 2025, the property does remain in violation. Heather, the office manager for Amir Houses LLC, contacted me for the first time on January 3rd to gain clarification.
Okay, and what did she tell you?
She was pretty insistent that there was not a violation. They were, I guess, confused about because everything else has really been cleaned up. It's really just the area by the shed.
Okay.
and they weren't looking at that area.
Meaning there's been a lot of improvement since the case started.
Yes, sir.
But that it hasn't been completed, and in any event, it's a repeat violation.
Correct.
Is it, to the best of your knowledge, abated as of today?
No.
Okay. All right, Ms. Chambers, Mr. Chambers, what's going on?
Yes, sir. We're not contesting this violation, so I'll start with it. I even went to the home last night myself. As I was speaking with Neil and his wife showed up, she said there was still some stuff around the shed that they were going to remove hopefully today. I will be going back out there tomorrow to make sure that they've complied, and then I will give Ms. Olson a call to let her know they've complied.
Do you know how repeat violations work?
Yes, sir. She just explained it to me, but
Yeah.
what I was going to say on that is that the time that you gave us for Gary Point is because it would have already been closed by her doing this repeat offense. But because of me and Mr. McGuire playing phone tag for a few days, we didn't get it closed, or won't be closed until today.
That's actually, so it's a repeat just by the fact that there was a violation on another property. In other words, whether it had been closed out or not actually isn't relevant for whether it's a repeat or not.
All right.
So that train left the station when she determined that there was a violation. But I think in the other case, you had a tenant as well, and you sought an eviction.
They were.
And you
yes, sir.
successfully evicted that.
Yes,
How
sir.
fast was that eviction process for you? I'm just curious.
It just happened like 2 weeks ago.
So it took a couple months?
Yes, sir.
Okay.
If I may say something,
Mhm.
sir, so on Clearbrook, the nephew, Neil, had congestive heart failure, and his uncle is actually bedridden because of a stroke. So he explained to me that's why the junk kind of accumulated, because both of their medical issues have kept them to the house ridden. Basically, his uncle's actually bedridden. But like I said, there has been a major improvement in from what I saw in the photos this morning to what I saw last night.
I think that's an explanation for why it's not cleaned up. I don't know that that's an explanation for how it got there, if that makes any sense. But in any event, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special magistrate assess a fine of $250 per day, along with the administrative costs to begin on the date of the posting of the property, November 26, 2024, and continue until January 14th, 2025. That would be 49 days at $250 per day, totaling $12,500, and a fine of $500 per day from this day forward until the violation is abated. We would also ask that the special master find that it is the respondent's responsibility to notify Code Compliance Division when the violation has been abated to allow for reinspection.
I'll tell you, normally I would do that, and I don't want to necessarily undermine what the county thinks is appropriate, but I think there are some mitigating factors here as to why I'm going to go down on the fine amount, and here's why. Number one is they have worked to, I think, promptly evict problem tenants in the past, and I think the county would want landlords to keep doing that. In other words, sometimes you can't control, I mean, sometimes you can, sometimes you can't, but it appears to me that they've tried to work with you on fixing the violations, which is important. I think the county's main concern is compliance ultimately. And the second is the testimony about with the tenant. It seems unrebutted that there are some significant medical issues which would require the landlord to intervene to fix it. If there was congestive heart failure, I have no evidence except what's been represented, but they're not going to be able to move that stuff. So that's what Mr. Charlton, did you have something you wanted to say?
No, sir.
So what I'm going to do is I'm going to cut that in half. I'm going to find that from November 26th to January 14th, a fine of $125 per day will be imposed. And from today's date forward, $250 a day until it's brought into compliance. I mean, honestly, that's very low for repeat violations. So I know it seems like a lot, but that's why I've put the findings on the record, and that's it.
Yes, sir.
Okay.
So the actual 125 started when?
Well, from November 26th to January 14th. So for every day that the repeat violation is in existence, a fine gets put on. That's what the code says.
Okay.
I have discretion as the amount, but not as to the fact of the fine.
Correct, sir.
Okay? Thank you.
All right, thank you. Thank you, Ms. Holt.
Thank you, sir.
Next case, this next case is a fine appeal.
Okay.
Taylor and Jamie Gill Sims, case number 2024-1218, Code Officer Cody McGuire, page 23 of your agenda.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your names.
Taylor Sims.
Jamie Sims.
Okay. Good morning.
Good morning.
All right, so this is a fine appeal, and normally on these, it's brought by you basically, not by them. So I actually don't necessarily remember the case. I'd love to hear what your basis for the appeal is.
There was a case brought against the pond, gravel road, and foreign soil. We built a new home, things we did after the process. Pretty much our understanding is it's our fault for believing contractors that said things that we could do without getting a permit. So in that being done, just unaware of not knowing we needed a permit, our fault. What we're here for is because there was already a case on all this, and we're unaware of it. Cody, I guess you're the one that's been to the property?
Yes, sir.
We live on a large piece of land, so the mailman doesn't see our front door. It's gated, so what was certified mail, I guess, was delivered to us to be signed for. We never got it, which stated stated that we were wrong and that there was a case about it. December 9th, we got this letter stating that we were gonna be fined. That's when we were first aware of all this. So since then, we've got the permit that needed to be done and all that stuff, and pretty much trying to fix everything that we were unaware of to begin with.
Okay.
That's why we didn't do any of this in the beginning, so.
Okay. Now, I just want to be clear, you got the letter for the fine, but not the prior letters.
Yes, sir. And there was a certified mail that they were stated was signed.
We'll get to that. But so my question is, were they both sent to the same address?
They were stated they were sent to the address this mail come to.
And I don't want to quibble, because I want to, what you're saying, everything may very well be true. But you testified that you live on a large piece of land and sometimes they don't even walk. How did you get the letter that you're saying you did get?
This letter was in the mail.
Oh, the other one wasn't in the mail?
That was certified mail, it says.
Okay.
And this
came
paperwork
regular mail.
says that we are notified by certified mail that we were to take care of this action. We were, we didn't get, I think it was 3 times.
But you do get mail at the property, correct?
We do,
Okay.
through the mailbox.
Okay,
But
all right.
something we got a sign for, we're not there. I mean, it's gated.
Okay. I mean, that's not necessarily the requirement, but so would you mind, do you have the exhibits from the prior hearing?
Correct.
Okay, so have you all seen the exhibits from the prior hearing?
No, but we understand what's going on.
Well, I don't, so I want you to look at what was in your prior hearing and let me know if you have an objection to it being evidence in this hearing so that we can talk about it.
Yes, sir. So, I mean, in these photos is, we had to build a driveway from our front gate to the house. So the contractors we hired stated that we could use dirt from a low area. They pushed it up, when they bulldozed, and they built the actual, base of it. Then the only foreign soils I brought in was lime rock. And I'm assuming that's what all this is, because it's an asphalt driveway is what it is. In the construction of the pond, we have cattle, so pretty much contractors just said.
How big is the property?
16 acres.
16. Well, here's what I'd like to do. Just look through these exhibits and let me know if you have an objection to them being evidence so that I can look at them as well.
Yeah, I mean, everything that's here is where we got a permit on now for just to, we
No,
would
I
have done
get that. Here's what I'm asking. These were exhibits at a prior hearing. So might seem more simple than it is. I just want to know if you have a legal objection to these documents being evidence in this hearing so that we can talk about them. I know you have things to say about them, and we'll get to that, but I just need to know.
I mean, yeah, they're at fault. I mean, technically by that book, I mean, I don't know the book, but I'm assuming they're at fault because that's why
Okay.
we're here.
Okay. All right, so if you're done looking at them, I'd like to see them. Mr. McGuire, would you mind grabbing them? And just that this will refresh my recollection. I'm kind of curious as to what I was thinking on my order.
You just picked this up from over there. Did they ever see this? Okay. You can't hand it to him without them looking at it.
Mr.
So give
McGuire,
them that.
would you mind giving me the photos, please? I'm tired of waiting. Thank you.
Give them this.
Yeah.
Okay,
this is what's in this here.
I do remember this. So
Yeah.
I remember thinking, because this is a little bit of a high fine amount for me, and I remember what my concern was is this this kind of work that is done without plans is normally, it's something that could lead to potentially water issues, things like that. And that's at least when I really wake up and take a look at things. So let me just look at the order here. I remember being surprised that there wasn't a response as well, which I think you've explained. Because there's really no hiding it. It's not a mystery as to what's happening.
And not in any, that makes it any better, but the property was agricultural before.
Mhm.
So when we started with it, we did all the permits for the home, just like, no, we pulled every permit to do everything else. And then closed that permit in December of '23.
Mhm.
Everything was permitted, obviously. And then that same month, the contractors that we're gonna continue the asphalt from the road to the house, so we can, it's cattle field, so I mean, it gets wet with rainwater, so, like I said, it's our fault for not knowing, but at the same time, they said, hey, you're a large piece of land, you can, as we built the pad for the house, we never brought in dirt. They just pushed dirt up from the field, built us a pad, so they said, same thing with that low spot, push dirt out of there, build you an asphalt road.
The gravel path and the filter, like that kind of stuff, isn't as big a deal as the pond.
So we pulled permits now to get all that approved.
Okay.
Like we would have did in the beginning. I'm only pretty much asking is that.
Well, let me talk about the pond for a second. So, like, what is that, and what kind of permits do you have to get for that?
Well, we have all they told us was a site improvement plan.
Yeah, and have you applied for the site improvement?
Yeah, we
plan?
have it here. Actually, we have it. It's already.
It's approved.
We just have to get inspections now.
It's it's approved. You just have to have it inspected and like finaled out. If
Yeah,
you
they
will.
gave it back to us. We just need inspections
Okay.
now. I guess someone, the engineers, I guess they come look at it or. It's a pond, just say, but I mean, right now it's about dried up, so.
Mhm.
The reason we stopped construction was the hurricanes came and it brought a bunch of rainwater and it filled up to the point where we couldn't do any more work to it.
Okay. Where, Mr. McGuire, did you give me a copy of the certified mailing stuff? Like, are all the exhibits here?
I thought they were.
I've got the order imposing fine. I have the administrative fees. It might be here. I could just be a lawyer. Oh, this. Okay, that's what I was looking for. How did they get this signature then?
Maybe that. To be honest, I don't know. It's a different situation. I've got no proof, but I wasn't even in the state of Florida that day. She was, I mean, I'm not gonna speak for her, but she was at a birthday dinner for her grandma in Inverness. And don't get me wrong, can't prove that that's my signature because I sign everything. You know, I mean, I don't have the same signature.
That's not your signature?
I asked my mail guy if he's ever presented certified mail, and he said he's never brought certified mail to my residence. So. Okay, it's a different case, but I couldn't tell you signature-wise. I don't even have the paperwork, or not even a neighbor said they signed for it and have paperwork for me.
I mean, I can show you.
We looked it up. We pulled it on the records and we looked it
Yeah,
up
what
to
I'm,
make sure.
so what I'm saying is that doesn't look like your signature?
Yes, it does. No, it does. I mean,
Okay.
I have like 100 different signatures, as in I just mainly scribble it on there, but.
Okay, but you're not ruling it out that that's your signature?
Yes, sir. Yeah,
Okay.
I mean, that's something, I just wasn't aware, so I don't know where that got signed or how that was. But I would tell you, if that was brought to my attention, I would have handled it to begin with, just as we're here today. Because since we've got this paperwork, I've contacted everybody we could do, every permit, every person.
I do permits for a living too, so.
Okay. What's the fine that has accrued, or, like, so the appeal is, I assume that I have an order imposing a fine at this point?
Correct. It was $400 a day.
Okay, so
It hasn't been recorded.
it hasn't been recorded.
No, because they requested a fine.
Okay.
When we found this out on December 9th, we pretty much were at the deadline. When this paperwork showed up, we were requested, I think we contacted you and
Yeah,
said,
and
hey,
the
we'd like
reason
to.
is that it appears that there's, record evidence of notice occurring on October 17th. So, the burden, theoretically, assuming you had notice, just for a second, the burden would be to comply,
Yes, sir.
starting then and not on December 9th. So that's what my thought process was on the 14 days. It seemed very flip, if you will. It doesn't sound at all like what your testimony is today. Honestly, if the evidence is that the property is essentially in compliance and the order hasn't been recorded, I don't know that I care, to be honest, because the point is compliance. But that's kind of what I'm thinking. Does the county have an objection to that?
To no fine at all?
Well, I mean, they have presented testimony that they didn't have notice. I have a signature here, and I'm curious what the county's case is. I mean, does the county have opposition to this?
Well, we would object to no fine, because
Okay.
Correct.
The certified mail is all that we have at this point to show that they did receive notice. We also posted, correct, or did we?
I've got this,
We
y'all
only got
posted
this
too.
one
Yeah.
in
I mean, it's
January.
just telling us this case here, but like,
Mr. McGuire, did you post on this case as well? Or did
Yes.
you just do
I've
certified?
never met him
Sir,
either.
if you
Oh, sorry.
would, this isn't your time. Please proceed.
So we did have posting happening at the address. We do have certified mail, which we take on face value. This is the first I've heard that it may not be true and accurate. And they have been out of compliance now for, it could be wrong, I'm not great at counting, approximately 38 days. So if you want to reduce it, we would have no objection, but we do feel like a violation did occur. As they've stated, they pulled permits for everything else. This could have been folded into a prior permit. It would have been very easy. It's something they chose not to do. If it's a misunderstanding, fine, but we do feel like a permit would still be, and a fine would still be appropriate for this case.
What's the amount that's accrued? Has anyone calculated that?
14,400.
As of today?
No, as of the 13th.
So
Okay, and so again, the reason why I had the fine as high as I did is because I was concerned that it was being blown off and that it could affect the health, safety, sanitary stuff of the, it's actually a fairly large parcel, but there was testimony that it could
Correct.
affect
Yes,
the
sir.
aquifer. Unfortunately, I mean, that's pretty serious stuff. I do think based on the fact that they've jumped on this since the fine, that it really wouldn't be appropriate to do. In other words, I don't have any evidence that anyone's gotten sick based on a dug pond on this property. I do find it a little incredible that there would be a forged signature, to be honest with you. And I'm not saying you're saying it on purpose. I think you've given truthful testimony, to be honest.
So the only thing I can think is on that is we never, anytime we need stuff signed, normally gets sent to our office. There's been times where the mailman, where I've signed paperwork before. He said, just sign this slip and I'll use it every time. It's the only thing I can think of is that. But he verified himself, said, I've never brought certified mail. In that case, he still would have left it with us, because if there's any package that would have got sent to us that we need to sign for, that anything, I'm trying to bring all this right. So all I'm saying
Yeah,
is,
it sounds like you have. Mr. McGuire, did you post the
The property
violation
was posted, yes, sir.
back in October, or
Uh,
the original violation?
You had certified.
Oh, yeah, no,
We have good service.
yeah.
Oh, you had good service,
Yes,
so
sir.
it wasn't posted at that time. Let me just look through this one more time.
Did they send certified mail 3 times? Is that what it stated?
In the order?
Twice, I think.
I think it was 2 or 3 times, but
They got-
I just find it
they
odd.
kept
The
getting
last
sent
one
back.
was signed, but not the first ones, and that being, like I said, it was this piece of paperwork that and we contacted Lori immediately as we found it.
I don't think I have the entire Exhibit B here, which is why there's supposed to be a notice of violation, notice of hearing, pre-hearing order, continuation letter, and certified mail receipt. So I don't have a copy of the continuation letter. I don't have a copy of the maybe I do. Hold on. I have the pre-hearing order.
The copy of the violations would have been Exhibit B.
Right. Did you give those to special master?
I only have Exhibit A.
Oh, you didn't bring exhibit B?
No.
Okay. Well, so what the record shows from the prior order is that I was presented with the things I just said. So that there was a notice of violation, notice of hearing. So the notice of hearing would have been sent. And there was a continuation letter, and there's a signed mail receipt for the current, I think that the time that the hearing was actually held. Here's what it says. A notice of hearing was issued to the respondents by certified mail on October 7th, notifying them of the November 20th hearing, and that's the one that was actually signed for. I think Mr. Sims is correct that according to the testimony at the prior hearing, a notice of violation was issued by certified mail on July 9th, 2024, instructing to abate the violation by August 10th. And this is just, it's all very odd to me that there'd be so many mailings, but the only mailing that you got was the fine.
Yes, sir.
I think what the county attorney has presented is unfortunately more persuasive to me in terms of keeping some kind of a fine, because when it's digging something into the ground, whether your contractor is responsible or not, you may have a cause of action against your contractor for negligence or otherwise. I can't give you legal advice. But I've been in your position, and I've known other people in your position having to rely on contractors to do this kind of work. And it looks nice, honestly. I mean, not the pond yet, but it looks like it'll get there. So, go ahead.
If in this permit, everything were to be approved and we paid an engineer to take samples and all, and they agreed everything was fine, would that overrule, I mean, if they agreed to everything, which I would have done in the beginning, if this is where it led to.
Here's the evidence really strongly suggests you had notice. I know your testimony.
The first 3 mails
Right.
certified, we never got. And the last one that they're saying he signed for.
But there's a signature that can't, there's a signature. It's not just, sometimes we get signatures where it's not the person either. Like it's someone else signs, and that's verifiable.
Well, the reason I say, I mean, don't get me wrong, but that's a very easy signature. I mean, you could scribble that yourself, so.
But why would anyone?
That's the question at another case, and I said it was, I have no clue, but at the same point is, why wouldn't I be here if there was a hearing? You know, just like I'm here today,
Well,
the moment we got this, I
it's a
jumped
good
on it.
question. You're not, I urge you not to stay to the end of this hearing, but you're gonna find there are a lot of people who don't show up. It happens a lot. It used to be the majority of cases. Now it's reversed. The majority of people show up, which is nice. People are vindicating their rights. just like you're doing, honestly, and I think it's just, I think that, so when you come and you want to testify that it's not your signature, you have to come with enough evidence to rebut the presumption that it is valid, because that's the case. It's actually presumed that this is valid, especially because it was sent to the address. So what I'm struggling with is I don't know that it overcomes that burden. And so what I'm going to do is I am going to reduce the fine. I'm going to cut it in half is what I'm going to do.
So.
And you can appeal that. You can appeal that.
Do I still get this fixed, or what's the outcome now?
Well, you
Because
need
I'm-
to, because it's going to continue to accrue.
Do I still go through this permit?
You must.
Okay, and if they approve it, I still have to pay the fine for?
Yes. Because there's been a violation, and you can appeal this order, mind you, but that's what I'm going to do. I'm going to reduce it.
And then appealing this order would be just appealing the fine amount?
Well, I mean, I urge you to consult a lawyer, because I can't give you legal advice, but the written order that I issue reducing this, or my decision, in other words, you could appeal saying, I got it wrong, I should have gotten rid of the whole thing, I'm not justified by the evidence, whatever, or I didn't reduce it by enough. Those are things to talk to your lawyer
So
about.
when does my fine start? Because we're in the process of permitting. What if the inspection?
No, it already started, and so it only goes away once you completely abate the violation.
I thought it was paused on December 9th for this hearing.
It just
That's what
wasn't.
we were
No,
told.
they haven't recorded it yet, because it's now gonna be, I mean, it's gonna be changed,
Okay, I
and
thought you
reduced.
had said that there was the fine didn't start because I had till January 15th that's what was stated was, I got this paperwork and it stated that I had to appeal this case by a certain date.
Yeah,
and
to
if I-
preserve your appeal rights. So if you didn't appeal it within a certain amount of time, you would lose the right to appeal, but you did timely appeal it.
But I was told by Lori that if I appealed this, that it froze fines until this hearing.
I said it wouldn't be recorded until your hearing.
You maybe specifically told me because
I would never
I
have said
recorded
that.
the word that
You should told me to. Because I asked.
until
at
this
one
hearing,
time.
because, and you
Well,
did
look,
say it was
let's think about this. Let's say that what you're saying is true. What does that change?
that my fine starts from today until I get it fixed.
No. But it doesn't. See, I'm the only one, I know what she told you, but it's incorrect.
So my fine.
Even, I'm not saying, I'm not finding by the way that she said it. I'm saying, let's forget whether you're right or wrong about that. It actually doesn't change your situation, because I'm telling you, I'm the only one who can make those orders, right?
Okay.
So whether she told that to you or not is actually irrelevant for your situation.
All right, so if I get this approved.
Correct.
When does it go to, when is this dismissed? When is my fine dismissed?
It's never dismissed. It's a fine that has to be paid.
Oh, I understand, so
Yeah.
I pay the fine, but when does the day stop? Because right now I'm still continuing to be fined, right?
When
Day
you
by day?
completely abate, okay, and that means your site improvement plan has to be approved and issued.
When that
Okay.
permit is issued and we see that it's issued, then your case can be closed.
Okay, so once I go through the inspections and they issue the permit's
Correct.
good.
Correct.
Then it stops. So when did it start? So I'm just trying to figure out the amount that I owe.
It's all in the order, and I encourage you to keep in touch with the county. This hearing's over.
Thank you, Your Honor.
Thank you, Laura.
Yes. Next case on the agenda, Christine Scheidler, case number 2024-1326, Code Officer J.C. Charlton. Expert on the case is Joanna Katu, page 32 of your agenda. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your names.
Christine Scheidler.
Rodney Scheidler.
Okay,
Thank you.
good morning.
Morning.
Good morning. J.C. Charlton, Citrus County Code Compliance Officer. This is case number CE 2024-1326, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address is 1227 North Circle Drive, Crystal River, Florida. The property owners are Christine Scheidler and Rodney Clay Scheidler. I have good service via signed certified mail return receipt. I'd like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos I took during initial inspection on July 19th. A corrective action inspection on August 30th. of 2024 and photos of subsequent inspection on December 6th and final inspection on January 14th of 2025. Exhibit B, copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a copy of the pre-hearing order, and a copy of the property appraiser summary listing the property as vacant.
So, ma'am and sir, you've probably seen how these have gone. Mr. Charlton, if you would, just hold on one moment. I'm curious, are you arguing whether there's a violation on the property?
Yes, sir.
Okay. Then I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. And take your time.
Oh, master construction, yeah.
All the different people that park there. when they're doing their
What now?
own- That's all the different people that park there to do their own construction on our street.
Nope.
Okay.
I would like to comment on when we get a chance.
Absolutely. Are there members of the public who want to speak about this case? Okay, and I see one. Is that it? All right, I don't see any others. Thank you, ma'am. All right, so without objection, what's been proposed as Exhibits A and B will be evidence. And so what I do is I let the county, because I don't really know what's going on until I hear from them first.
Yes, sir.
But Mr. Trent, let me just look real quick, just so
Yes,
I
sir.
get the lay of the land, so to speak.
Okay.
All right, please proceed.
I conducted my initial inspection on July 19th, 2024. I observed boat trailers and a truck on vacant properties zoned Coastal Lakes Residential. I've had contact with the property owner, Mr. Scheidler, and explained the violation and explained that this is the second violation on this property, and the previous one was closed because the items were removed, but they go and they come. As of my final inspection on January 14th, 2025, I observed vehicles on the property, on the vacant property, and I'll now turn it over to Land Development Director Joanna Coutu.
So it's about 0.3 acres in size. It's a residential lot. It should be vacant. They have a house across the street from this site, but not abutting it.
It's across the street?
Correct.
And this is waterfront?
Yes.
Okay. Is it on a lake or a river? Or?
It's a canal.
It's a canal. All right, is that it?
Mm-hmm.
All right, I'd love to hear what y'all have to say.
Okay, thank you. Yes. So a couple of things. As you can see in the photographs, the vehicles change, like the ones when I called the officer and told him that it was cleaned off because I removed everything that was, quote, my property.
Right.
The vehicles looks like in the photos are construction vehicles. I have a permitted replacing my windows in my home, and the contractors parked there. The term storage is probably the biggest issue I have, and also my council has, because we can't get it defined anywhere where it really says, what is the definition of storage? We park there, we move stuff. I have my own vehicle there. Yes, I understand my primary residence is across the street, but they are, they're contiguous, except there is a street in the middle, I will admit.
Mm-hmm.
But we're not using it as storage. We use it as temporary parking.
Mm-hmm.
And like I say, looking in the code, we've reviewed it. We can't see where, the code 1 prohibits as an accessory use to have parking on it. And you'll see several times the vehicles do change because we move them out. We're not leaving there for long term.
I think, here's what I'll just tell you my immediate thoughts are. We've had a lot of these cases. And so I think what and this is true in other counties and cities as well that have very similar codes. Storage usually means just simply placing something on it. In other words, if you had a park bench there, you know, is it storage? I mean, or whatever, but if you had a couple coolers, that's considered storage because you're putting it there. That's, by the way, any order, you can feel free to appeal if your counsel, do you have counsel?
Yes, he's not here today. Yeah, Robert Batzel Sr.
But Batzel's great, okay?
Yes.
He's a legend. And I appreciate his legal opinion and his son's. In any event, used to work at that firm. So I think that that's the way that the code reads. Am I incorrect about that?
No.
Let me ask you this. Is temporary parking allowed on a vacant parcel without a principal use established?
No, that is a use.
Okay, so that was my second point, which is you've conceded the violation already by saying that you use it as temporary parking, for better or for worse. So what this code says is that unless you get that principal use established, you just can't, there's very little that you can do. I think you can put up a fence. Okay.
Yep.
There's very little that you can do without having the principal use established. So, you're not, are you saying this is a repeat violation?
No, it's not a repeat violation because it was never found guilty,
Oh, okay.
but I had a previous case before that I closed when the items were removed, but
So
then we
y'all
got
worked with the county
another call.
before on
Yes,
whatever,
I have.
taking the
Yeah,
stuff
and
off the
like
property?
I say, yeah, I'm trying to work with them, but
Yeah.
you know, I don't think it's out of the realm to park there. You know, I really don't. You know, and to be honest with you, I let my neighbors park on there, and they're doing construction on a home next door. They're lifting it because
Don't
of the
be
flooding.
honest with me. Don't be honest.
I'm
with
being
me.
honest.
If you have to, I mean,
You asked me to raise my hand, so I have to be
There's
honest.
so much is too much honesty,
No,
perhaps.
they just
but
show up and park there.
Yeah.
We'll be like, who's parking over there? There's
look.
nowhere to park on our street.
Yeah, we have a very small
We're like,
street
who are they? We don't know.
in Circle Drive.
That last white van on there, that wasn't anybody to do with us.
Then you might want to think about a fence.
Well, the other option is you want people parking in the street, and the street, like I say, it's a very small single-lane street. You know,
That's
so
not before me today. I mean, I just got to tell you, I have to apply the law consistently with the way that it reads.
can I ask you? Go ahead.
No, please.
Can you show me in the code where it states that we're not allowed to use parking?
3102
A.
A.
Do you have an exhibit of that? We myself and Mr. Batzel reviewed it and cannot find where it does not list parking as an accessory use.
It's any accessory. I think it's any accessory use is, so it's not a matter of exhaustively listing what those uses are. It's any accessory use without the principal use. I would like to hear from the public. Yeah.
Do you swear or affirm?
Actually, ma'am, are you in favor or against?
In favor.
Okay, then you can stand at that podium.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And can you please state your name?
Mary Marr.
Thank you.
Welcome.
Thank you. I live on North Circle Drive. I live past their house and their lot. I can confirm our street is extremely narrow. You have to wait for the garbage trucks and the delivery trucks and the FedEx and UPS. 2 cars cannot pass unless they're very small. This is one of the only vacant lots on the street, and I can attest that everybody uses it. Construction people, delivery people, cars, they pull off so other cars to pass by. And it's not any long-term use. Nobody stays there overnight. Nobody does anything else, but it is constantly used by the entire neighborhood. So if they do fence it out, it'll definitely be a problem for the rest of us. I can attest that it's caused potholes and mud and collecting and everything else in front of their home, and they never complain to any of the neighbors because they do understand our street is narrow. And I can also say that their cars may be in there during the day temporarily while somebody else is getting in and out, but his truck's in his driveway every night. It's not across the street on that lot. So it's definitely a temporary, not constant parking there of their own vehicles. And any other questions you have for me, I'm happy to answer them for you.
I don't. I'm well persuaded that this is not evil at work. You know, I'm well persuaded of that. And, but again, I'm going to ask Ms. Coutu to speak on this. Well, anyways, actually, ma'am, I appreciate your testimony. I don't have any questions for you.
Okay.
Ms. Coutu, I was wondering if you could, I know this probably drives people nuts. I like to explain things. And so in 3102A, it says accessory uses or structures may not be placed on residentially zoned property prior to the establishment of the principal use. It doesn't limit that. It's all accessory. But why is that the case?
Good question. The commissioners adopted that because we have people putting things in the middle of their neighborhoods. Sometimes they're sheds or truly what you would call storage in that case. Sometimes they're vehicles parked there. Sometimes people live there. You've had a lot of cases before you. So this is trying to establish that there's not going to be in the middle of a neighborhood a vacant lot with some suddenly things on there. People camp there.
Or junk or debris.
Or junk and debris, absolutely, but anything.
It's really not for the. It's really not designed. I mean, I don't think it's intended to stop people like you from doing what you're doing. To be honest, I think it does. But the reason is that I think if you have a bunch of residential lots and they're all vacant, you might have people just throwing stuff on there and look. This is the way it's formulated.
Yes. Yes, sir.
I'm going to give you a time to comply before any fine begins. How much time do you need?
I honestly, when I called the officer and the inspector, I thought it was taken care of, but I was out of town yesterday. We've been out of town. We was in Jersey for a couple of days on business, and I thought it was empty because all my property, quote, owned by Scheidlers, was off of it, and because they're doing work on our home, again, not having them park in the street. Those you know, as you said, those are, you look at the photos, there's different vehicles.
No doubt about that.
Yeah, it's not like you see the same thing. And
Correct.
every vehicle there, to my knowledge, has up-to-date Florida tags, and we move it, and it's all legal vehicles. It's not something we're like storing junk for better off.
Here's the big picture. I mean, so I assume you don't need much time. I assume
you should be able to go there right
10
now.
days.
Honestly, right.
So we'll do 10 days, but here's the big picture. Because the county is obtaining a violation now.
Yes.
Y'all have waited and seen the other hearings. There's the potential for a repeat violation case coming down the line. So that's what you want to avoid.
Yes.
And just work with the county if you do want to use the property on establishing a principal use.
Okay.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that Special Master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and the respondent's actions relative to this violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
It's just going to be 10 days, and if it's not brought into compliance in 10 days, it'll be $50 a day.
All right.
That's it. Okay?
All right.
Good luck.
Thank you.
Jonathan and May Assumption Rector, case number 2024-01801, Code Officer Cody McGuire, page 28 of your agenda.
Good morning, sir.
Good morning, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name.
Jonathan Recta.
You're gonna have to spell that for me, please.
Oh, no, it's the name that's on there,
Oh, it is.
Mr.
Okay.
Recta.
I'm sorry.
All right. Mr. Recta, before we proceed, I'm curious, are you contesting whether there's a violation or not?
No, basically, I just need to, ask some time to help my tenant to, clean up the area.
Okay, you have a tenant on the property.
Yeah.
And how much time do you think you need?
Maybe 1 week or 2 weeks. 2 weeks the most.
Oh, goodness. I mean, is there any reason that you can think of, Mr.?
No, sir.
All right, why don't we put what your case is on the record? Just tell me about the case. What's the a state alleged violation?
It's junkyard conditions. It's just a few loose pieces of debris, a cooler, not much.
Okay. And again, you're stipulating that there's a violation, correct?
Mhm.
And is that a yes?
Yes.
All right. And is 14 days sufficient to take care of it?
Yeah.
All right. So what's the county's recommendation?
$50 a day.
Okay. There's a violation. You have 14 days to bring it into compliance. If you don't, $50 a day.
Yes, sir. I
Thank-
understand.
Thank you, sir.
Thank you. Thank you.
Next case
He
on the day's,
stipulated. There you go.
on the day's agenda, James Sidner, case number 2024, 1948, Code Officer Erica Olson, page 32 of your agenda.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name.
James Siner.
Thank
Okay.
you, sir.
Good morning, Mr. Steiner.
Good morning.
Good morning, Erica Olson, Citrus County Code Compliance Officer. Case number 202401948, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20 Tech 31 Alpha of the Citrus County Code of Ordinances. Address is 6025 South Gray Oak Terrace. This property is 1.11 acres and is zoned RUR-MH. Owner is James Snyder. I have good service via signed certified mail return receipt.
Sir, are you contesting whether there's a violation or not?
Well, there is not now.
Okay.
I've been cleaning it up.
So you're saying that, to the best of your knowledge, as of today, there is no violation?
Right.
Okay. Did you inspect it yesterday?
I did, sir.
Did you feel that there was a violation yesterday?
Yes, sir.
Was there improvement, as Mr. Steiner had testified?
There is improvement in the front. When I first went out to the property, it really didn't look like much. Yesterday, when I was out at your property, there wasn't a truck in the driveway. So I was able to see in the back of the property, and it does look like there is a lot of stuff. However, I will say that he has brought in several dumpsters, so
To take care of it?
to take care of it. So, I mean, obviously, I haven't seen it today,
All
but
right.
yesterday there was a violation.
Mr. Steiner, it sounds as though the county still believes there is a violation. Now, let's assume for a moment that there is. If there was, based on what you just heard from her, how much time would you need to clean it?
3 months, because I'm getting another roll off. I'm having the company I work for is bringing me a roll off so I can get rid of all the metal that's there.
All right, then, my concern is that if you've represented there isn't a violation, so if you're close, you shouldn't need 3 months necessarily,
Okay,
right?
2 months then. I mean, as long as the weather's permitting, because I'm not gonna work out there in the rain, or I'm not gonna work out there when it's 35 degrees. I'm sorry about that.
No, you're a good
You
Floridian.
know, I'm not gonna go out there and get sick and not be able to do
No,
nothing.
I'm with you, okay. I'd say 60 in my case. So let's go through the case and let's walk through it.
I would like to take the time to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on November 7th, 2024. My corrective action inspection on December 3rd, 2024. And photos of my final inspection yesterday, January 14th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Sir, I'd like to ask you to take a look at these documents and let me know if you have objection to them being evidence.
So they're in order by date, and then these are just the documents you received.
Yeah, that's garbage that's thrown in the one dumpster now. All right, that's why I got a dumpster and a roll-off. And you can see there, I had stuff on the trailer.
And so, sir, really all I need to know is if you object to the photos, you'll have the opportunity to comment, and frankly, they agree with you that you've made improvement. While they're doing that, is there anyone from the public who wants to be heard on this case? Okay, I don't see anybody.
I'm trying to get everything done. I mean, I'm by myself, so, you know, it's hard to do 3 things at one time.
I'm not arguing that. I only want to see the photos so that I'm on the same page looking at what you're looking at and understanding what might be a reasonable amount of time. Okay, without objection, Exhibits A and B are evidence. Thank you. All right, let me take a look here. Oh, I see. Hmm. Oh, I definitely would have to say, Mr. Stein, there's still a violation on the property. And it is gonna take an amount of time, yeah.
That's why I'm asking for time.
Is there anything else you wanna testify to on this?
No, sir.
Okay. Do you have any immediate, have you had any reports of rodents?
I have not.
Okay. Are you aware of any environmental department investigations or anything that would give you a concern for the health, safety, sanitary stuff on the
I don't have any reports, sir.
property? Okay. Well, I mean, I'm definitely gonna give you time to comply. What's the county's recommendation?
I recommend $50 per day along with administrative costs to begin after you deem a time sufficient to abate this violation.
It is gonna get cold out there from what I've seen.
Yes, I know.
But it's, why 3 so here's what I see. I see tires, I see some car debris or vehicle debris of some kind. I see a lot of just interesting stuff. I feel like 3 months is too much time. And I know you said offer 2. But normally in these cases, what I'm trying to do is, I think 45 days is enough. I think you can do it in 45. I think you can do it in less, to be honest. You have the dumpsters, right? You already have them.
I have a dumpster right now for the garbage.
Okay.
I don't have the roll-off for the metal yet.
Oh, but you're getting one.
I'm getting one.
How long will it take to get that?
Well, I talked to the guy yesterday, and he said at the end of the month, they're gonna have all of them gone. So I'm gonna have to wait till I get another dumpster. Cause I was gonna put the bigger stuff in the dumpster.
Okay.
That.
Okay, all right. Then in that case, I'll do 2 months and $50 a day.
Thank you.
All right, thank you.
Okay, so how much, when does that start?
After 2 months. If you haven't fixed it on the property, after 2 months, a $50 a day fine will begin.
Okay.
Okay, thank you.
All right, thank you.
Next case, Unique Homes LLC, case number 2024-1972, Code Officer Erica Olson, page 33 of your agenda.
Oh, I'm sorry.
That's okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Marin Weeks.
And so are you an agent or owner of Unique Homes LLC?
I am the owner.
Okay, thank you. Please proceed.
Erica Olson, Citrus County Code Compliance Officer. CE 2024101972, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. Address is 6049 West Green Acres Street, Homosassa. Property owners, Unique Homes. This property is approximately 2.42 acres and is zoned RUR-MH. Have good service via signed certified mail return receipt from the owner and the registered agent.
Okay. Sir, are you contesting whether there's a violation?
No, there was definitely a violation there. I have the papers from the county. I filed for eviction, started in the 1st of November. Matter of fact, when I went out and put the 3-day notice, when I seen their letter there for that.
Sure.
Plus, the owners that I rented to had already moved out. The problem is the daughter's living there, and she has a lock on the gate, Ms. Olson knows. I cannot get in. I was told I can't cut the lock. I can't do anything.
Yep.
I talked to Judge Thomas's assistant yesterday, and Judge Thomas is in training all this week. She's a new judge, I guess, that just.
There's a new judge named Judge Thomas?
Yes.
Yes.
Who was appointed?
Yes.
She was elected.
Yeah, that's what he
Or
told
who
me.
was elected? What's her name?
Amber Thomas.
Amber, yes, Amber Thomas.
Mhm.
Okay.
And so she took on the cases originally with another judge, so that could be some of the reasons it's been taking so long. 'cause
Did
this
she
is-
defeat someone in the election? Like, obviously she defeated someone, an
I-
incumbent?
No, I believe it was the empty position created by Judge Helm when he was elevated to
To
circuit
take
court
up
in
some of
Lake
these
County.
cases because they're overloaded. So
Got
this
it.
has been sitting there since November, I have, if you want to look at it.
No, I believe you.
And as soon as the
how
sheriff
much-
cuts the lock, I will have a dumpster there the same day or the next day, and I'll get it
But
cleaned
you
up.
have a suit pending that would remove the squatter, so to speak.
So I can go cut the lock,
No.
you saying? I was told by Don.
No, I'm sorry.
Oh.
No, I'm not giving you permission to cut a lock.
I think, I've been doing it
I
today.
don't have that kind of authority.
And plus the girl there, we don't know if she's of age or not, so I'm kind of leery going on the property with her there.
Okay, what I'm asking is, I just want to confirm that the lawsuit you have pending is to obtain possession of the property?
Yes.
Okay. Are you represented by counsel?
No.
Okay. Is there anyone from the public who wants to be heard on this? Okay, are you in favor or against?
I'm in favor of
Okay.
them, but against the people that live
There you go.
there. I live
Okay.
right next door.
I got it.
I'm in 6029.
I got it. First, let me just, do you have any idea how long it's gonna take to do the
I
run through
talked
this?
to Mrs. Amber's assistant yesterday. She said Miss Amber's and Judge Amber's and
Right.
training.
Electoral
And
college
she'll
or
be there
whatever it
Monday,
is.
and she promised me she would put it
Electoral
right in
college.
front of her Monday to sign. Now, if she does, I have no control.
Okay.
But I mean, I can show you where it's been filed and everything's been done and it's signed to Judge Amber.
Well, I
Promise.
need to usually give you a time to comply. I want to be reasonable, and I'd love to hear from the public. So, sir, would you come up and tell me what you have to say?
He's absolutely right. Those people that live there.
Sir, if you don't mind, why don't you come on up and,
I need to swear you in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I
so
do.
help you God?
I
Can
do.
you please state your name?
Michael Joseph Potter.
Thank you, sir.
all right.
I own the property adjacent to 6049. I'm 6029, and since these people moved in there, they have been the worst. I mean, they're holding the whole neighborhood hostage. They're up all night, and the reason the yard's in a mess is because they're up all night, and then they sleep all day. And the latest thing was a bunch of hammer in there till late into the night, and I noticed all the aluminum fascia and soffit's gone off the house now. I mean, they are slowly dismantling the house.
Are they melting it down? I mean, I mean,
They're
what are they
taking it
doing?
and cashing it in.
Okay, yeah.
I mean, I have no doubt what I gotta do to the house.
Oh, yeah, they've destroyed the place. It's unbelievable. And they've tormented me the entire time. Every night they're out there banging on shit, just trying to keep the whole neighborhood up all the time. And I've noticed even the cop that lives on the other side of me, he's out there sitting in his car in the middle of the night, because that's how much they're out in the neighborhood causing trouble. And they're still out there doing it all the time. They hit my cameras with laser pointers and shut my cameras down and come on my property at night and steal shit. I mean, these people need to go to jail.
By the way,
Or anybody
before
there
using,
besides the daughter now?
but, sir.
I don't see
Sir,
anybody.
before using language like that, can you give me warning so I can cover my
Okay.
ears? Thank you. I
Well,
think,
if you live next to them, you'd understand. That's all I can say.
And the father was arrested 2 weeks ago for bath and needle, I don't know if you.
well,
Yeah.
the issue for me, of course, is that I have very limited remedies. I assess fines
Right.
more or less just when there's a violation. And it
Right.
almost seems as though it'd be unfair to, punish a landlord based on the violation. But you are taking steps, so I want to look, on a standard type eviction, you file something, they usually don't respond. It can be done quickly. I don't know if you have much experience with that, but.
I can show you everything.
I
Well,
know,
I mean,
I'm
everything, it keeps
telling
going, shows
you-
everything done, and it just says, then it was signed, first it was assigned to Judge,
I know. What's the county's recommendation?
$50 a day in administrative costs.
All right, I'm gonna give 60 days to bring the
Okay.
property into compliance.
Yeah, that'd be
So a
plenty.
fine won't start. That should give you enough time to try and get rid of these folks.
Lord knows they ought to sign it by then.
And if it's not brought into compliance as ordered, there will be a $50 a day fine.
Okay.
Okay? Good
All
luck.
right.
Us in the neighborhood actually thought they were out January 1st, but apparently they got some kind of reprieve. So
Yeah, they changed judges.
And they made a point to make sure everybody in the neighborhood knows that
Wow.
they're still there.
Well,
You
good
know?
luck. Good luck.
Appreciate you coming down.
No problem.
Next case, Amir Ali Giovanni, case number 2024
0679, Code Officer Cody McGuire, page 26 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Amir Ali Jiwani.
Thank you.
Okay. Good morning, sir.
Good morning.
Please proceed.
Okay. Cody McGuire, Citrus County Code Compliance Officer. Case number 202400679, Special Requirements for All Accessory Structures, a violation of Citrus County Land Development Code 3102A. Address is 6381 West Tangerine Lane, Christian River. It is zoned LDRMH and it's 0.16 acres. The property
Mr.
owner.
McGuire, please slow down.
Yes. The property owner is Amir Ali Javini. Good service via signed certified mail return receipt and posting out at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on April 24th, 2024. Photos taken during a subsequent inspection on June 27th, 2024. Corrective action inspection on December 11th, 2024. And photos of my final inspection on January 14th, 2025. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
I am aware of everything.
Okay, so sir, are you contesting whether or not there's a
No,
violation?
no, sir.
And you understand what the basis is?
Yes.
All right. How long will it take you to fix the problem?
Okay. First of all, I live in Panama City area. So I drove all the way here and I talked to Mr. Cody McGuire and his supervisor basically. And I was not aware that anybody was living on my empty lot. So yesterday was the first day I confronted, but I called the sheriff department because I didn't want to go alone myself. And they says, as long as I'm here, you can be here. Well, I'm here, but you cannot be here in this property until someone is here as a local law enforcement. So I said, okay. So I went to the court yesterday and filed eviction notice yesterday. And hopefully, once they get them out, and I will pay appropriate fee for the sheriff department and all that to make them move out or so. But according to talking to them in the front of police officer, and police officer was asking them questions, the officer itself recommend that these people are not very easy to get off.
Mm-hmm.
So I don't know what it takes time, but I am for it. And the day, and it's a lot of trash in the back, front, and in the all that. So, but I cannot go inside and clean up everything right now until they've been gone.
So what's the violation here?
Junk
What are they
and
doing? Like, what's happening on the property?
there's an RV on the property that's just starting to get junky.
Okay. But neither the junk nor the vehicle are allowed to be on the property?
Correct.
Because there is no principal use established?
Correct.
Have you had contact with the person who's there?
I've had contact with many persons there.
Oh, wow. How big's the property?
1.6 acres. Very small.
Well, this is one where there may be, based on the testimony, health, safety, sanitary concerns. I mean,
I've had the health department go out there and they came back with nothing.
wow, okay. What do you want me to do?
Assess a fine.
Okay. All right, so sir, it looks like you've started the process already. Now, in order to abate this violation, basically everything's going to have to be removed from the property.
Absolutely.
Yeah. Frankly, this doesn't sound like an eviction to me. I encourage you to seek your own legal counsel, but you don't have a lease with anybody on the
No,
property,
sir.
right?
No,
So-
I do not even know who they are.
Right. So there's different causes of action you can consider. It's irrelevant.
Yeah.
You're seeking possession of the property. But even if you get when you get an order from a judge, you will get help from law enforcement to I expect you will, to remove anyone else in possession of the property. But do you have any idea how much time you would need?
This is the first time
Yeah.
in my lifetime and this has ever happened. So, and I'm living 4.5 hours away from it, so I wouldn't know. But until once they clean up, I'm gonna go ahead and sell it out and get rid of it.
How far is Panama City?
Almost 5 hours from
5
here.
hours? All right, I'm basically gonna do the same thing I did in the last case, which is give 2 months to try and get through it. Sometimes they get done as fast as 7 days.
I love to, and I like to ask you one thing. There is I only have is one person eviction because the cop only can give me one person name, and in order to give his name, he have to get the permission from that guy only. But there are other 2 people already there with him.
You need to consult a lawyer, okay? And so I do think there's a way to knock it all out in one.
Okay.
This is a vacant piece of property. There's
Yes,
no
sir.
house there. You
Yeah.
don't have squatters, okay? So I think I can't tell you, all right? But I encourage you to speak with a lawyer.
Okay.
Because it's doable,
Thank
okay?
you. Thank you.
All right, that's it.
Thank you.
Thank you very much.
Thanks.
sir.
And
Next
it'll be 50 a day if it's not brought into compliance, okay?
Next case, Kevin and Brenda Wright, case number
Thank you, sir.
2024-1962, Code Officer Alan Jonason, page 38 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning.
Good afternoon.
Close.
It's
we're
getting there.
close. Yeah, no, you're,
Yeah.
we will get there, but
Mr. Wright,
Yes.
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 202401962, special requirements for all accessory structures, a violation of Citrus County Land Development Code, section 3102. The address of the violation is 7975 North Walton Terrace, Citrus Springs, Florida. Property owner Wright, Kevin, and Brenda. This property is .44 acres and is zoned PDR and was purchased on 1 December 2012. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 13 November 2024, photos from a compliance inspection on 16 December 2024, and photos from my final inspection conducted on 14 January 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, a copy of the posting affidavit, and a copy of the property appraisal.
can you give me a narrative of what the violation is?
Storage, they had a shed on there, and now the shed has been removed, but there was a structure behind the shed made of pallets. There's a bunch of other junk and debris on the property.
Okay. Does it make sense what they're alleging is going on the property?
Yeah, the narrative specifically is we're building a home. We got the permit issued, everything was going fine. I wasn't aware that there were time deadlines to get inspections as we were proceeding. Last year was very difficult. There were health challenges. Also, did you know we had 2 hurricanes and some other storms going? So we had a number of challenges last year, and we were unable to do the groundbreaking that we wanted. So unbeknownst to me, I found out later that the building permit had literally lapsed. And in the meantime, of course, the shed is there. I was thinking everything was fine. We were just waiting to do the groundbreaking. I have a family member who is a long-term resident here of Citrus County. The story was that we were going to involve him in the building process, and he was happy to do that. And lo and behold, to find out that more or less behind my back, he decided to move into my shed and store what he has recorded on those things. I wasn't aware of all this going on. When I did find out what was going on, and then find out that my building permit had been, I started working towards getting into compliance. We're a long way towards getting into compliance. I have some additional photographs for evidence as far as what we were able to accomplish after he visited the property yesterday and cleaned up. So there are still some things left to be cleaned up on the property. They are fully cognizant of what needs to be moved. The only thing that's slightly inhibiting that particular process is this quote-unquote family member who was supposed to be a friend who ended up living in my shed. He's in the hospital in the ICU right now. So he has things which are important to him, which are on the property. Given the fact that I literally think that he's dying of cancer right now, I don't know how long this situation is going to go on. I hate to have to just haul it up because apparently there's a county dump not too far there and they just dump it all off. I'd prefer for him to find a place to take this stuff that he has left on the property. I don't think he's going to be able to be capable of doing that. I'm going to try to work it out with him as best as I can. But the way I'm seeing it right now, he's closer to a funeral than helping me with anything with the mess that he's created on my property. So I appreciate the county's work in helping me, correct this situation. I really appreciate seeing all the other situations that you have dealt with here today and the leniency that you've showed to different individuals, different situations. If you have any questions for me about this, I'd be happy to entertain them.
I guess I need to see the photos. Yeah. So if you would, let me know if you have any objection to these documents.
That shed is, of course, has been moved.
Well,
yeah.
I just need to know if you have an objection to them being evidence. So take a look through them if you would, or if you don't have an objection, then they can be evidence.
Yeah, no, that's what,
Okay.
my picture shows too, except the only thing that is not shown is the work that we did
Thank you.
in the last 24 hours to try to come into as close to compliance as possible. There is a small amount of building materials and a small amount of personal property that's still on the premises, which we fully intend to move. There are a couple of pipes that are there, more or less as barriers to try and keep vehicles off the property, sort of as impromptu fencing and stuff, because there is a problem in this neighborhood with homeless people and other people coming on these properties and camping out or doing what they will.
Is there anyone from the public who wants to be heard on this case? So I've looked through the photos. I think I have an idea of I think all the testimony I've heard is consistent with the photos. Mr. Johnson, have you heard anything that you disagree with?
So I would like to go through this because
please.
I have there's some dialogue that's being omitted from.
I don't want to deprive you either. Yeah.
Okay. On 13 November 2024, I conducted my initial inspection and observed the property to be in violation. On 13 November 2024, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance mentioned earlier. On 16 December 2024, I conducted a compliance inspection and observed that the property remained in violation. I have had spirited contact with the property owners, and as of my final inspection on 14 January 2025, the property remains in violation.
That sounds like a euphemism.
Yes, sir. So my dialogue with Mr. Wright here has been nothing but professional, and what he has stated is absolutely the truth.
Okay.
It's the other party, I believe, is his spouse, Brenda. I spoke with this gentleman on 4 December 2024. I referred him to the building division. He said he was going to get in contact with the building division, and I believe he did. And then a second call with him also was on 16 December 2024, and we spoke about the building permit and what he needed to do. I referred him to the building division.
Or the fact that there was an expired.
Absolutely.
Yeah.
And I just referred him to the building division. He understood, and we went from there. The third and fourth call came on 30 December 2024 by, I believe, Brenda Wright, who was very combative on the phone. Stated that House Bill 1365 allowed her to let homeless people live on the property. I explained to her that was a public property.
Please, sir, please, may I say something here at this point?
Sir, no. I'm
Okay,
sorry, sir.
okay,
No,
okay.
no, I mean, you will, I'll give you every opportunity to be heard, but Mr. Jonason was patient.
She stated that House Bill 1365 allowed her to let homeless people live on the property. I explained to her that that referred to public property and didn't, you know, have anything to do with this property.
Are you familiar with that bill?
I
mean,
am,
I don't know if I've
absolutely.
heard of it.
Absolutely, absolutely. It's a bill that the governor signed that if a community decides to create a homeless area, that they can do that. They're allowed to do that.
Oh, this is the 120,
1365.
what is it?
1365. House
Well,
Bill 1365.
I know the statute. I mean, we talked about it in Claremont last night, actually.
Sure.
Okay, I know exactly what you're talking about.
Yes, sir.
Okay.
And so I tried to set her straight.
It forbids counties or municipalities from expressly allowing
Absolutely.
public, regular public sleeping.
Yes, sir.
Yes, I get
Yes,
it.
sir.
Right.
Okay. And then we ended that call. Again, it became spirited. And then the fifth and sixth call came yesterday. Same person, I believe, Brenda Wright. I explained to her about the posting of the property, how that went. She initially said that she did not receive the notice of hearing via certified mail. Now, I did get good service on the notice of violation, but I did not get good service on the notice of hearing. So, of course, we post those on the property. She called me a liar and said I never posted on the property. The conversation became even more spirited. She called me a fucking asshole, and then I said, ma'am, I'm sorry, I have to end this call, and then I ended the call.
Okay.
And I just wanted to get that on the record as far as the case goes.
So, Mr. Wright, I have asked code enforcement in the past to let me know when interactions like this occur. And the reason why I've asked them to let me know is because I do take it into consideration when there's, I call that an aggravating factor, so to speak. And there is an old phrase, sins of the father, sometimes they're sins of the spouse. They're not necessarily visited on the other, okay? But it's important for me to know what the nature, is there a desire to come into compliance? Is there not a desire to come into compliance? And certainly I want to give you an opportunity to speak in response if you'd like to.
Please forgive my wife. She doesn't know what she's doing. I know she treated you badly on the phone. I don't know how many times she called you or whatever, but the background on that is that for the last several years, my wife's health
I
has
encourage
been
you, by the way, that if you
deteriorating.
don't need to share private health information, that you don't. In other
Okay.
words, I'm not going to, I just want you to know this before you reveal something. This is on YouTube, you know?
Okay.
So I'm not assessing a fine today. What I'm going to do is I'm going to give a time to bring the property into compliance. I think that's what you're going to ask for, is
Yes,
for me
sir.
to give a time to bring the property into compliance, and then a fine at the end of that if it's not brought into compliance as ordered. Okay? So given that knowledge, I just want you to think real hard before revealing any confidential health information.
Okay. Again, I've always known this board to be extremely fair on all your rulings, and I'm just asking for mercy in this particular situation at this time because it's a whole lot of stuff that I've got to try and put the toothpaste back in the tube on. So if
Let's assume I find a violation. Are you going to be the primary person fixing this?
yes.
Okay. And,
And,
you know,
and
in
one
looking
thing I
at
would
it,
like to ask is that if another call is made by my wife, just say fine, you know, whatever, just humor her. And
well, they have an obligation to deal with the public too, you know, and ultimately it's your wife's call until you have a guardianship order. So I think that I'm not meaning to give you advice. I'm saying she has rights too.
I know,
She has rights.
I know.
So, in looking at the photos, I actually don't. I thought it would be worse. I'm not saying it's good.
Well, I have
when I
some
hear Mountain of
additional-
Pallets, I really was hoping for more, Mr. Jonason. I was hoping for
my
3-4
apologies.
stories.
My
You know, like
Well,
if
I'm
a
not
Universal Studios attraction is what
Sir,
I was
I'm not
looking
sure
for.
I used the the word mountain.
Oh, I thought I heard mountain,
I'm pretty
but
sure
I
I
mean-
said a structure
Oh,
made of pallets.
you're right. I heard mountain, and
Yes,
you
sir.
said structure.
Yes,
That's
sir.
my fault. Sir, if you would, that's not evidence.
Yes, sir. If you want to present that, you'd have to give your phone.
Yeah.
And we would keep your phone.
Here's what I'm gonna do. I am going to, I mean, it's a bunch of loose, there's a lot of loose materials. The pallets have been arranged.
Would you like to see my photos from
Well, I
yesterday?
can't unless you want us to take the phone and keep it in our custody.
I could print these out and bring them back to you later today.
We're gonna have the hearing today, right now. So the time to do that, it's in my pre-hearing order as well, you know, so I try to explain that ahead of time.
Well, I'm at the mercy of the court, so I think you're going to basically make a ruling in my favor here. I don't want to deter that, but to just
I'm ruling
accept
it-
my testimony that the property will be cleaned up. It has been cleaned up
Yeah.
substantially since yesterday, and we're moving since.
Okay.
So, you know.
Yeah, what I'm agonizing over is the amount of time. I don't see, or I don't think
If you could give me 60 days, that would be helpful because my pickup is in the shop right
Okay,
now
what's the
when it's
county's
in-
recommendation?
$150 per day.
All right, you've got 60 days, and if it's not brought into compliance in 60 days, 150 a day.
And administrative costs as well.
Well, those are always incorporated
Yes,
as
sir. Okay.
standard provision.
Yes, sir.
Okay?
Thank
All
you.
right.
Good luck.
Thank you.
Thank you, sir.
Next case, Efren and Hermes M. Rivera, case number 2024-1877. Code Officer Alan Jonason, page 29 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 202401877. Citrus County Land Development Code, Section 4002, Site Development without a development order or permit. Address of the violation is 4436 East Garden Street, Inverness, Florida. Property owner is Rivera Efrain and Rivera Hermes M. This property is .31 acres and is zoned MDR and was purchased on 1 February 2023. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 24 October 2024, photos from 14 January 2025, and an aerial photo from the property appraiser's website from 6 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the notice of hearing posted on the property, a copy of the posting affidavit, and a copy of the pre-hearing order, and a copy of the PA, property
Okay.
appraiser.
Is there anyone from the public who wants to be heard on this case? I don't see or hear anybody, so in any event, exhibits A and B are admitted without objection.
On 24 October 2024, I conducted my initial inspection and observed the property to be in violation. On 29 October 2024, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance mentioned earlier. On 11 December 2024, I conducted research with no permits issued, and a notice of hearing was issued. As of my final inspection on 14 January 2025, the property remains in violation with no permits issued. I have had brief contact with the property owner who asked what was going on at the property. I referred them to the building division and land development, but I never heard back from them. Joanna Coutu, Land Development Director.
Okay.
So they do actually have a permit. It's been sitting, December 20th is when it was approved, and fees have not been paid, so it hasn't been issued. So it's been waiting for fee payment, and then they can have a permit for a house.
Wow, okay. What's the county requesting on this?
Requesting a one-time fine of $5,000 along with the administrative costs.
Oh, man, they've made an effort, but nonetheless, I understand. So I will find that there's a violation, and I will assess a $2,000 fine.
Thank you.
Next case, River Oaks RV Campground and Retreat LLC, Case number 2024-1282, Code Officer J.C. Charlton, expert on the case Joanna Katu, page 30 of your agenda.
Now, to the extent that photos exist in this, they won't have been taken by you, correct?
There is photos from the final inspection that I took
Oh, okay.
yesterday.
All right.
Yes, just one set.
All right.
J.C. Charlton, Citrus County Code Compliance Officer. I'm standing in during this case for Code Officer Brandon Norman. It's case number CE 2024-1282. This is a violation of Citrus County Land Development Code, Chapter 2, Section 2401, Low Intensity Coastal and Lakes Districts. The address is 2000 South Bishop Point, Inverness, Florida. Property owners, River Oaks RV Campgrounds and Retreat, LLC. Have good service via signed certified mail return receipt. Excuse me. I'd like to authenticate the following documents and request to be admitted into evidence. Photos that were taken during an initial inspection on July 18th, a corrective action inspection on December 24th, and a final inspection that I conducted on January 14th of 2025. Exhibit B, a copy of the notice of violation, notice of hearing, copy of the signed certified mail return receipt, and a copy of the pre-hearing order. Exhibit C, screenshots from the website, from the RV and campground website, showing that the property is active as a RV site and taking and currently taking reservations. A copy of the property appraiser summary and a copy of the district table from the Land Development Code.
Wait, so what's happening on the property?
The violation?
Yeah.
The violation is land use districts.
Well, I mean.
They're running an RV park without a permit.
Okay, got it. Well, that's what I'm kind of looking for. All right, is there anyone from the public who wants to be heard on this case? All right, I'll be happy to take a look at the exhibits.
Okay.
Thank you. All right, exhibits A, B, and C are admitted without objection. Let me just take a look. I always thought I got in the wrong line of work once I realized how well you could do with an RV park. All right, so has there been any contact with the owner?
I haven't had any contact with the owners regarding the violation. No, I haven't.
I mean, it looks fairly clear from the photos. Ms. Katu?
So this is an old non-conforming RV park. Our code has a magic 365-day trigger of if you're not permitted operating within that time frame, you lose that kind of grandfathering, valid non-conforming use. They did close in November of 2023. I've worked quite a bit with the health department. We're both trying very, very hard to try to get them there. They did apply for an operating permit with the health department in September of 24, so that is less than a year, but they were not approved. We think they can modify their application to possibly get approved, which will backdate and get us all in the right thing, but right now they're not.
They need some pressure to understand
They
that.
need to revise their operating permit request with the health department, and then they have to dial back. They have too many lots they're asking for, which never was approved. So
Okay.
they have some dial back. We're trying.
Got it. All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate to the severity of the violation, respondent's actions relative to this violation. We would ask the special master additionally fine it was respondent's responsibility to contact Code Compliance Division for reinspection.
60 days, $100 a day. Sir, are you here as a respondent? Okay, all right. Is there any specific case you're here for? All right. I would just call it up if you were waiting.
Did we do Cassidy?
I'm sorry?
Did we do Cassidy?
No, we gotta do Cassidy, she's not done. No, she's not. Next case on the agenda is James Cassidy, case number 2024-1515, Code Officer Cody McGuire, page 18 of your agenda. Land Development Director Joanna Coutu, expert witness on the case.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 2024-01515, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is going to be 1158 North Pompeo Avenue in Crystal River. It's zoned LDR and it's 4.40 acres. The property owner is James Cassidy. Good service via posting the notice of hearing on the property and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on August 3rd, 2024. Photos taken during a corrective action inspection on September 6th, 2024. And photos of my final inspection on January 14th, 2025. Exhibit B is going to be a copy of the notice of violation, copy of the notice of hearing, copy of the continuance letter posted on the property, and a copy of the posting affidavit and a pre-hearing order.
Okay, is there anyone from the public who wants to be heard on this case? Not seeing or hearing anybody, exhibits A and B are admitted without objection.
All right. On August 3rd, 2024, I conducted initial inspection and observed an enclosed trailer on vacant property. As I was conducting the inspection, two dogs come running out of the open gates when a man from the property came running behind them to close them. As he was closing them, he told me to stay off his property. On August 29th, I received mail from the property owner. On September 6th, 2024, a corrective action inspection was conducted, and there was still an RV, 2 cargo trailers, 1 4-door Ram, and a little red car. I've only spoke to James that one in particular time in person, and as of January 14th, 2025, the property remains in violation.
What's the county's recommendation?
$200 a day along with administrative costs.
All right, 14 days, and what was the fine recommendation?
200.
200 a day. Thank you.
Thank you.
Next case, 74 South Lincoln Ave, LLC, case number 2024-1910. Code Officer Julie Wilkinson, page 5 of your agenda.
All right.
Yes, sir.
Julie Wilkinson, Citrus County Co-Compliance Officer. This is case number 2401910, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 74
I
South
call
Lincoln.
this a Becker violation.
Yes, the Becker Special.
That's right.
The address is 74 South Lincoln Avenue, Beverly Hills, Florida. The property owner is 74 South Lincoln Avenue, LLC. I have good service via posting the, excuse me. Posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on November 1st, 2024. Photos from a corrective action inspection on November 27th, 2024. And photos from my final inspection conducted on January 14th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
This is a year-long overgrown lawn case?
No, I'm pretty sure I gave you a wrong date.
Oh, okay. When were the first photos taken?
The first photos were taken on November 1st, 2024.
Okay, that makes a lot more sense. All right, I'm with you.
Okay.
Is there anyone from the public who wants to be heard on this case? I don't see or hear anybody. Exhibits A and B will be introduced as evidence without objection. Thank you. Did you take the photos in Exhibit A?
Yes, sir.
What's your recommendation?
My recommendation is $100 a day along with the administrative costs.
14 days, $100 a day. Again, admin costs are standard provisions in all my orders.
Okay, thank you.
Next case, Norma Kane, case number 2024-1476, Code Officer J.C. Charlton, page 8 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer, case number 2024-1476, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of Citrus County Code of Ordinances. The address is 7313 South Sioux Terrace, Floral City. Property owner Norma Kane. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Photos taken during an initial inspection on November 14th. Corrective action inspection on November 22nd, 2024, and a final inspection that I conducted on January 14th of 2025. Oh, and I want to add the follow-up inspection also from December 31st of 2024. Exhibit B, notice of violation, notice of hearing, photos of the posted property, a copy of the posting affidavit I completed, and a copy of the pre-hearing order.
Any contact with the owner?
No, sir.
Is there anyone from the public who wants to be heard on this case? Okay. Exhibits A and B are admitted without objection. Thank you. What's the county's recommendation?
$100 per day.
Is there anything else you want to tell me about this case?
No, just overgrowth and scrap tree debris on the front and back of the property.
It seems as though the main parts of the growth that are problematic are closer to the house. Is that correct?
And then the very back is completely overgrown. They didn't try to mow back there.
I see. Okay. All right. I'm sorry. What was the recommendation?
$100 per day.
I'm going to give 30 days on this one and $100 a day.
Thank you.
All right.
Next, two cases on the agenda. Philip C. Chung, case numbers 2024-1899 and 2024-1859. Code Officer J.C. Charlton, pages 19 and 20 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number CE 2024-1859 and CE 2024-1899. Excessive growth and accumulation of vegetation, Chapter 20, Article 6, Section 20-61, and accumulation of junk and debris, Chapter 20, Article 3, Section 20-31A, Citrus County Code of Ordinances. The address is 3675 East Bulldog Lane, Inverness, Florida. Property owner Philip C. Chung. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Photos taken during an initial inspection on October 29th, 2024. Corrective action inspection on December 2nd, 2024. And final inspection on January 14th of 2025. Exhibit B, notice of violation, notice of hearing. Copy of the photos from the posted property, copy of the posting affidavit I completed, and a copy of the pre-hearing order.
Are the photos the same for each case, or are they separate?
They're the same.
Oh, they're the same?
Yes, sir.
All right. Exhibits A and B are admitted as evidence in each case. Is there anyone from the public who wants to be heard on either of these cases? I neither hear nor see any response. Looking at first the, actually, I'm not sure which one is.
It's the excessive growth first.
Yeah. Actually, I'm just trying to figure out how these have been organized. Oh, I see. So it's just one Exhibit A.
Correct.
And,
Yes,
okay,
sir.
got
It's
it.
the
You didn't
same-
give me two
same-
Exhibit As.
No, I didn't.
Got it.
No.
All right, let me just look through real quick. Yeah, the overgrown yard looks really simple. Have you had contact with the owner?
No, sir.
Do you know if anyone's had contact with the owner?
There was a log note stating that contact was made, but.
Nothing else about the
nothing.
contact?
No, sir.
All right, I mean, on the junk scale that we've established, from 1 to 10, this is a, I mean, what would you rate it?
Probably 3.
Yeah, I was gonna say 2.5.
Yeah, I mean, it's.
Nonetheless, anything on the scale is a violation. And, all right, what's the county's recommendation on each case?
For each case, a fine of $200 per day.
Okay, I will find a violation in each case, and on the overgrown yard case, we'll do 14 days, $200 a day. On the junk case, also 14 days is really just not much. It should take a matter of, honestly, minutes, not hours.
Right.
And $200 a day.
Thank you.
Okay?
Next case, Elizabeth Ann Faust, case number 2024-2010. Code Officer Alan Jonason, page 22 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-02010. Unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. Address is 4716 East Parsons Point Road, Hernando, Florida. Property owner is Faust Elizabeth Ann. This property is .33 acres and is zone CLRMH and was purchased on 14 March 2019. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 25 November 2024. Photos from a compliance inspection on 10 December 2024. Photos from my final inspection conducted on 14 January 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, photos of the notice of hearing posted on the property, and a copy of the pre-hearing order.
Is there anyone from the public who wants to be heard on this case? All right, I see no response. Exhibits A and B are admitted as evidence.
On 25 November 2024, I conducted my initial inspection and observed the property to be in violation. On 25 November 2024, a notice of violation was issued for unlicensed vehicles, which is a violation of the ordinance mentioned earlier. On 10 December 2024, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 14 January 2025, the property remains in violation.
Recommendation?
$150 per day.
All right, 30 days, $150 a day.
Thank you.
Thank you.
Next case is Ryan Lee Willard, case number 2024-2012 and 2024-20. Did he step out?
He's walking in right now.
Well, we can get another one before, and then we'll get Alan. Case Christine Williams, case number 2024-2022. Code Officer Alan Jonason, page 37 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-02022. Unlicensed inoperable vehicles, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances.
In Williams? I've got a
it's a
junk case.
No.
No? Okay.
Nope, 2022 is
It's just what's on my
unlicensed vehicle.
agenda, but that's fine.
It's
Junk
unlicensed.
in the computer.
It's an unlicensed vehicle case.
We can proceed, I mean.
Okay. Address of the violation, 4870 North Longbow Loop, Hernando, Florida. Property owner is Williams Christine. This property is .06 acres and is zoned LDR MH and was purchased on 1 July 2004. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 26 November 2024, photos from my compliance inspection on 19 December 2024, and photos from my final inspection conducted on 14 January 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, photos of the notice of hearing posted on the property, and a copy of the pre-hearing order.
Without objection, what's been proposed as Exhibits A and B are evidence. Is there anyone from the public here to speak on this? All right, I don't hear or see a response. Please proceed.
On 26 November 2024, I conducted my initial inspection and observed the property to be in violation. On 26 November 2024, a notice of violation was issued for unlicensed vehicles, which is a violation of the ordinance mentioned earlier. On 19 December 2024, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 14 January 2025, the property remains in violation.
Well, I'll just make an initial comment. I don't find that to the extent there's a different description of the violation that that's an issue. For a quasi-judicial hearing, the case has been noticed. I find that sufficient. Furthermore, I think what's most relevant is the notice that's been provided, and looking at what's been proposed as Exhibit B. Notice of violations out there, notice of administrative hearing is, seems consistent. So, all right, I think, like I said, Exhibits A and B are admitted as evidence. It's two
vehicles, a motorcycle and looks like a van of some sort.
What's your recommendation?
$150 per day.
30 days, $150 a day.
Thank you.
Thank you.
Last two cases, Willard Ryan Lee, case numbers 2024, 2012, and 2024, 2066. Code Officer Cody McGuire, page 35 and 36 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer.
Is it working?
It is.
You're
Okay.
reverberating. You
I'm
can back off a little bit, actually.
I'm sorry. Case number is 2024-2012. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A. And case number 20240266 is unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 8470 North Windbreak Terrace. The property owner is Ryan Lee Willard. Good service via posting the property and posting at Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during my initial inspections on December 2nd, 2024. Corrective action inspections on December 16th, 2024, and photos of my final inspections conducted on January 14th, 2025. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, a photo of the notice of hearing posted on the property, and a pre-hearing order.
Is there anyone from the public here to speak on either of these final two cases? I don't hear or see anybody. Exhibits A and B in each case are admitted without objection. And please proceed.
Okay. On December 2nd, 2024, I conducted initial inspection and the property being in violation. A notice of violation was issued for junkyard conditions and unlicensed inoperable vehicles. On December 16th, corrective action inspection was conducted and the property had remained in violation. I have met up with Miss Willard several times and have communicated with her on the phone. She said she couldn't come today because of work, but they are actively cleaning up the mess. And as of my final inspection on January 14th, 2025, the property remained in violation.
What are the vehicles that are subject to this?
The 2 boats.
Oh, it's just the boats?
Yes, sir.
Okay. She allowed you on the they allowed you on the property?
She did. It was her boy, and a friend.
Okay. What's the county's recommendation?
$100 a day per violation.
All right, on the inoperable vehicles, I'm gonna do 30 days and $100 a day, you recommended?
Yes,
Okay,
sir.
we'll do that. And then on the junk case, has there been improvement?
There has. So they were actively cleaning it up when I pulled up one time, and it started to rain, and that's whenever they just kind of left it there.
Okay. I'm concerned about the amount, I mean, this is a 4 to 5 on the scale. I'll do 30 days. I mean, it's not that much. I'll do 30 days and $100 a day.
Thank you.
Okay. Is there anything else that the county wants to bring up before we adjourn? Anything from the public, sir? No. All right, then the time is 12:18. This hearing is adjourned.